come together to engage in an enriching dialogue on the future of online dispute resolution. Today, we stand at the crossroads of legal innovation and technology, and this platform brings forth a unique opportunity to explore how ODR can revolutionize the justice delivery system. With an illustrious lineup of speakers and thought leaders, we are set to embark on a journey of insightful discussion, exchanging ideas that will shape the future of dispute resolution.
Before we officially begin, let us take a moment to acknowledge and appreciate the dedicated efforts of our organizing team for curating this exceptional event. We would like to extend our gratitude to eVarta, the organizer of this symposium. eVarta offers online dispute resolution with a focus on mediation and arbitration services. eVarta's mission is to provide a secure and convenient online platform for resolving disputes efficiently, affordably, and transparently. Through their vision, eVarta has created this invaluable platform for dialogue, learning, and problem solving in the field of ADR. A special note of gratitude goes to Paryaya, the ADR Society of LC1, Faculty of Law, University of Delhi, a dynamic initiative dedicated to bring about awareness and innovation in the field of alternative dispute resolution. The ADR Society strives to provide a platform to conduct panel discussions, lectures, and training workshops, while also stimulating a research-driven culture among students. We extend our heartfelt thanks to the team for their invaluable contributions in making this event a reality.
I now request Professor Dr. Sunanda Bharti, Dr. Shilpa Bagre, and Mr. Yogi Makkar, please come on stage and take this. He's a distinguished professor of law at the Faculty of Law, University of Delhi, a certified professional mediator. Professor Bharti brings extensive expertise in ADR. She also served as editorial team leader at Lexis.
Can we also have Professor Anil Singh and Professor Anand Sir on the stage?
Ji, Binod, Anand ji, Yogi ji, Anurag, Professor Anurag ji, Dr. Anand Singh, dear esteemed guests of the dais, my students, friends, ladies and gentlemen. It is a pleasure to welcome you all to the Symposium on Online Dispute Resolution, ODR. As technology reshapes the legal landscape, ODR stands at the forefront of accessible, efficient, and cost-effective dispute resolution. At the outset, I would like to acknowledge the efforts of Avinash, the person behind eVarta. I claim him as one of our own because he is a student of Law Center 1, where we teach. Now, when he approached me with this idea, I wanted to gauge the potential of this initiative. And I'm happy to state that Paryaya, the ADR Society of Law Center 1 Faculty of Law is delighted to be not being recognized either in the standees or on the banners. Paryaya is nowhere to be seen. But nonetheless, बहरहाल हम पूरी तरह से ये claim करते हैं कि अविनाश हमारा ही बच्चा है. So, and every effort towards promoting and creating awareness on ODR needs to be applauded. So here we are, and let's see how we can move from here, what we can bring to the table with this thing. Because court dockets are overburdened, and this is no news. Court dockets are overburdened, there is a huge pendency, litigation is expensive, and access to justice remains a challenge. ODR offers a viable solution by leveraging technology to resolve disputes seamlessly, reducing delays, and ensuring inclusivity. Today, as I stand here to deliver my opening remarks, I have a lot of expectations from the speakers. And I would ideally want the discussion, whatever we present here today, to ideally revolve around the focus areas on ADR or ODR. And as I was trying to organize my thoughts in the morning, I jotted down 5 main points which ideally I would like to see some deliberations upon insofar as ODR and its scope in India or across the globe is concerned. So the first point that came to my mind is legal framework and policy developments around ODR. And there are many questions that grew in my head when I look at this concept or look at this topic, that is legal framework and policy development. Say for instance, how has India integrated ODR into its legal framework so far? What are the key policy measures by NITI Aayog and the Supreme Court regarding ODR? How do existing arbitration and mediation laws facilitate ODR? Do they facilitate it in the first place? And where are the gaps? Because I'm sure my limited knowledge of arbitration and mediation tells me that yes, there are a lot of gaps, and it would be great if some of the speakers here today can deliberate and throw some light on those gaps. Should ODR be made mandatory for certain categories of disputes? This is an area which requires a lot of research and hence excites me a lot more than other topics revolving around ODR. What global best practices can India adopt in its ODR policy framework? So these are some of the points that came to my head when I jotted down that first point on legal policy and framework regarding ODR. दूसरा बिंदु जिस पर मैं चाहूंगी कि कुछ तो वार्ता हो, कुछ तो बातचीत हो, कुछ तो deliberations हो, वो है of course technology and AI, that is artificial intelligence in the context of ODR. And as I was looking at the lineup of speakers, I realized that yes, we do have speakers who will be speaking on artificial intelligence and ODR. Now here, there is a lot of brouhaha, there is a lot of noise that is being made on the scope of artificial intelligence in general, scope of the potential that artificial intelligence holds in the domain of ODR, online dispute resolution. All that is okay, and yes, discussions on that front also are necessary. But what I would be interested in is in knowing or in having some deliberation on the limitations of artificial intelligence in resolving disputes, especially those that require human empathy. Empathy, kindness, compassion, these are essentially human virtues. Can any artificial intelligence, no matter how smart that might be, can it replace these essential human virtues? virtues, if at all? How can technology be used to enhance access to justice rather than replacing human decision makers? I would love to listen to a perspective that is different than that of mine, because my point of view is that these essential human traits cannot and should not be replaced by any artificial intelligence. Third point is in regard challenges and barriers in relation to ODR. What are the key obstacles preventing widespread adoption of ODR in India? How do we address issues of digital literacy and access to technology, or if I may say digital illiteracy and inaccessibility to technology, especially in rural areas? Because there is this huge challenge that we need to create a counter to if we are to ensure that ODR has some scope in India. What are the regulatory challenges that must be addressed to build confidence in ODR mechanisms? So these are in regard challenges and barriers. The third point that my mind sort of jotted down. Fourth is in regard availability of ODR. Can ODR help small businesses and individuals who otherwise cannot afford litigation? Because that is how ODR is projected. But can it really live up to the expectations that have been put into ODR? How do we ensure that ODR platforms are accessible to non-tech savvy users? Because we need to have some sort of technical savviness when we talk of online dispute resolution. What role do legal aid services play in ensuring that ODR is available to vulnerable groups? Because I see a clear potential there. Our legal aid clinics can do I think, if not earth-shattering work, but yes, groundbreaking work here, provided we give them that kind of a direction. Last in this availability on ODR is, should there be incentives for businesses to adopt ODR for resolving customer disputes? Because that way we can ensure that ODR gets that kind of a backing that it deserves, or that it is projected to deserve in India. The last point is, in my understanding, also a very, very important point that requires deliberation, and that is future of ODR in India. And here, the first thing that we need to deliberate upon is what steps are necessary for mainstreaming ODR in India. And here, and why mainstreaming ODR? Because so that it becomes a part of the collective societal functions, that whenever they think of a dispute, they should think of resolving it through the online mode. So, in the Faculty of Law, University of Delhi, at least in the 3-year LLB course, we have made our small attempt at mainstreaming ODR by including it in our curriculum. And when we talk of Faculty of Law, University of Delhi, 3-year course, and now even the 5-year law school has come up, we are talking of 10,000 plus students. That means our small attempt, this is our small attempt at introducing or creating some level of awareness in regard to ODR in the collective functions of the society. Because when these students graduate and they come into the real world, when they start practicing, they would be at a certain level, they would be aware, or it is expected that they are aware of at least this stream of, or this mechanism, this forum of dispute resolution, which we call online dispute resolution. Now, will ODR evolve to handle complex, high-value disputes, or will it remain limited to small claims, is also an important aspect linked to the future of ODR. Any discussion that has to happen in relation to future of ODR in India has to cover this point as well. Platforms like Sama and Agami, I've heard and I've read, have successfully resolved thousands and thousands of disputes using ODR mechanisms. Similarly, some major e-commerce platforms, they also have integrated ODR to handle consumer grievances efficiently. However, so ODR is trying to, make its presence felt, and it does have its advantages. But it is extremely crucial for us, academicians and think tanks, to also address the critical concerns surrounding ODR. Can ODR replace human adjudicators completely? Should it replace human adjudicators completely? What are the implications if it does? What are the implications that it is likely to have on justice or access to justice or the future of human work, employment? Are we prepared for a future where AI resolves disputes with minimal human intervention? These thought-provoking challenges require urgent and critical discussion. With this symposium, I hope we can collectively explore how ODR can transform dispute resolution in India while upholding the principles of fairness and justice. So, without taking much time, I think I've exceeded my time by 2 minutes. Let us begin this dialogue with an open mind and a commitment to finding some solution. Or if we are not in a position to find a solution, or if we say that, okay, this is too much of a task on our head, then at least we should be in a position to deliberate on crucial issues, brainstorm on crucial issues revolving around ADR. Thank you so much. And
Thank you so much, ma'am, for providing us with such a compelling start to this event. We are privileged to have with us Justice S. Mukherjee today. It is an honor to have you with us, sir, today.
Now I would like to request Advocate Dr. Yashpal Sharma, please join us on the stage.
Now, let us proceed with today's esteemed lineup of speakers who will be sharing their expertise on various dimensions of ODR. Our first speaker, Dr. Shilpa Bagare, is an advocate on record at the Supreme Court of India. She holds an LLM in International Law and a PhD from RTM Nagpur University on transboundary water resource management under international law. She has served as course coordinator at the Sushma Swaraj Institute of Foreign Service MEA and a resource person at the Institute of Military Law and Indian Law Institute. Today, she will discuss the international perspective on ODR. Please welcome Dr. Shilpa Bagare.
Greetings to all. I respected dignitaries on the dais, my dear students and friends. So, as already topic has been declared, I am speaking on international perspectives on online dispute resolution. I have divided my thoughts in two folds. First, one is about the technological perspective, and the second one is about the legal perspective. Because ma'am has already touched both the perspectives, and she requires deliberation on that. While deliberating it, I have been an international law student. I have just focused on international law. For deliberation in India, it will be a more bigger canvas again for me, and that requires a separate research paper, I think so. So I have deliberated on that, and the constraint of time limit also, because students or the audience will be get bored with the one speaker. So considering within those constraints, within 10 minutes, I'll just deliberate on these two perspectives, that is the technical perspective and the legal perspective. See, this concept is not new at all, because after like the COVID period, we have everybody has faced a lot of issues. Even the courts were stopped that time. After that, there is the evolvement of the online medium, and now by deliberations of the Supreme Court, every court has become the e-court now, and while equipping every advocate, it may be over 70 years old, or the advocate may be of a junior to me also, or the pass out also, has to equip with this e-portal, e-system, e-mechanism. So, I see in the Supreme Court day-to-day basis that every senior, though maybe of a 70 plus, but they have adopted this situation, and this is the positive sign that though e-commerce is coming, codes are coming, e-things are developing, so e-ways we are developing. Literacy thing, yes, we need to deliberate on that. So in a rural villages also, we have seen that the Facebook has become, like see in my rural village, I have seen that though I am not on a social media platforms, but I come to know that the people who are not in any field also, they are on Facebook. And they are very active than any expert I have seen. So this, if we grow this literacy, automatically this will not be a challenge for ODR. Then for international perspectives, if we think of technical infrastructure is the main issue for the ODR. Because in a technical infrastructure, you have to be very sound. Because cyber security is a great major in that. Because you know, when you have a platform also, there are lots of threats into that. Because when you provide an online platform, you need it, there should be a cyber security of information, encryption, data protection, and authentication of protocols is required. For that purpose, there are various techniques available, that is security protocols such as SSL and TLS must be implemented to ensure for the data implemented, for data transmission, storage, for purposes. For this, these security protocols are very much required, and this is the strictest security condition. Then we come to the blockchain. Okay, in a blockchain smart contracts in ODR, we found their benefits and functions. And this is the again safest mechanism, you can say, wherein whatever transmission of a data is there, that the privacy issue, privacy aspect is totally protected in that. This blockchain system is very well established, and it the contracts building a chain from scratch. Okay. And in that, we have seen that this blockchain explores essential tools for real-time activity, visualization within these distributed networks. Then we come to the data privacy concern, particularly in cross-border transactions. Because due to globalization, there are extremely increase in cross-border transactions. In that, we need to follow GDPR and then international privacy laws. So in that, data privacy concern, especially in cross-border dispute, become critical when managing sensitive information across the different jurisdictions. European Union's General Data Protection Regulation and international privacy law provide the regulatory framework that outlines the requirements and safeguards to ensure that the personal information is maintained under strict condition of security and confidentiality. In this context, using digital certificates such as SSL and TLS emerges as a fundamental pillar in protecting communication and verifying identities of the involved parties. Then we come that authentication is another element in this process. When the server sends the public key to from the SSL or TSL certificates to the browser, the latter dataset or manipulate data. This process ensures communication, confidentiality, interactions, reliability within a digital environment. Then we come to the, because it is again a one paper for the data privacy itself. So I just shifted to the legal perspectives. Now the first, when we shift to the legal platform, legal issues in regulation of ODR platforms, when the first issue coming to my mind, that is enforceability and recognition. Because when there is a ODR, outcome of any ODR, outcome of any decision, how it will be recognized and how it will be enforced. For that, in international forum, we have UNCTRL Model Law of International Commercial Mediation and International Settlement Agreements resulting from mediation 2018 aims to address this issue by providing a framework for enforcing international settlement agreements. The UNCTRL Model Law on Electronic Commerce and United Nations Convention on Use of the Electronic Communication in International Contracts generally support the recognition of electronic signatures, e-agreements in ODR contexts. Then come the procedural safeguards. When we think about the procedural safeguards, what should be a procedural safeguard? Herein again UNCTRL has given very, you can say, comprehensive guideline for that, wherein it has considered the what we call it a principle of natural justice always, that is fairness, transparency, then compliance with due process of standard, including right to be heard, equality of arms, adapted to the digital environment, transparency requirement for ODR providers regarding their decision-making process, potential conflicts of interest. So developing international standards for ODR, procedural fairness potentially through instruments such as UNCTRL technical notes on ODR is crucial for fostering the trust in and recognizing ODR outcomes across jurisdictions. Then comes the issue of jurisdictional complexities. Herein, always there is what should be in a cross-border dispute, what should be this is a great challenge. What should be a jurisdictional, what should be the jurisdiction? Then there is the principle of autonomy in the choice of law clause may be constrained by mandatory rule of the forum by overriding mandatory provisions of third-party countries. In the absence of express choice, conflict of laws, rules of paramount with potential application of the closest connection test or the law of characteristics performers' habitual residence. Jurisdictional challenges exacerbated in ODR context due to virtual nature proceedings. So targeting the online activities and effect doctrines in the digital realm. Then question comes the applicable law in cross-border disputes. Then determination of applicable law in ODR remains a complex issue. Principle of party autonomy, or then comes to the allowing party to choose the governing law, is generally respected but may be limited to the mandatory rules of forum. Overriding mandatory provisions of third-party countries and public consideration. Here, some international provisions are there. Without party choice, courts or ODR platform may resort to Rome I regulations for contractual obligations in EU, the closest connection test, or the law of the characteristics performance habitual residence. These traditional conflict of law rules may require adaptation to suit the unique nature of online transactions and disputes. Then there are a lot of challenges. I directly touch, may I touch to AI or leave it to for a science, sir. I think I should not touch this topic, but AI would be one of the challenge. Okay, and I think really Professor Anand sir will deliver it on that, and that is a great issue in that. But as I have touched for the international law and private international law as well. So in that, for AI is a robust mechanism is available for us, and especially for the family laws and small commercial disputes. Okay, wherein even eBay or PayPal, if we see, it's very efficiently it has come up. So it can be used because day by day, family courts are overburdened in India. So we can use AI for at least some solving some pressure of the courts, at least issue of the litigations can be solved through the ODR also and this AI. Then I'll conclude, like already I have focused on the blockchain, AI left for the Sir. So in conclusion, I will just say that digital mediation platforms are solidified their position as essential pillar in contemporary conflict resolution process, and their ability to provide efficient solutions tailored to the involved party needs ensure their longevity and enhances their relevance in increasing digitalized environment. And lastly, these technologies will streamline dispute resolution and ensure adherence to ethical standard, setting a new precedent for conflict management in digital era. Thank you.
Thank you, ma'am, for sharing your time and knowledge on jurisdictional challenges in ODR and unilateral principles. It's been an honor to have you here.
Now it's my pleasure to introduce Shree Binod Anand, an alumnus of JNU and Bamicom. He is a member of Prime Minister's Committee on MSP and Agricultural Reforms and the National Biodiversity Authority. His leadership in CNRI and the World Cooperation Economic Forum is widely recognized. Today, he will discuss farmer-centric online dispute resolution and its impact on jurisprudence.
Thank you very much for the very nice introduction and very timely one. In fact, we were together discussing the farmers' issues only, the three laws and body. So on the dais, this is a very new place for me. Though I am a student of law, just registered, when I discovered that law I need to understand now. So I am Binod. I come from a very poor place on paper, that is Bihar, and but very politically and spiritually and categorically very rich place, where you have to go if you don't want to come on the earth again. So I welcome you all to sometime come to Gaya, the place where candidates are this. And I thank Avinash to invite me as an odd man out. But while I was listening to ma'am, I discovered that why I am here. And of course to you, ma'am. So I represent two organizations, and that's two voluntary organizations. The one is Confederation of NGOs of Rural India, where we had with NALSA, Bharat Vikas Yatra, during Congress regime, and given to honorable judges to dispose of. Somehow things are not at right place. That was in 2007. Later on, when I discovered that the समस्या की जड़ गांव में है, then equality is inequality, असमानता सारी समस्याओं के मूल में है, और कोर्स क्यों है, थोड़ा वेद में और बाकी चीजों में थोड़ा एक्सप्लोरेशन किया जब वो क्यों इतने बायस हैं और हमारे देश को समझ नहीं पाए, हमारे वैल्यू चेन को समझ नहीं पाए, हमारे एग्रीकल्चर वैल्यू चेन को तो बिल्कुल ही नहीं समझ पाए, लेकिन सारा रूल वहीं से करते हैं। तो मैंने सोचा कि दो चार बातें मैं आपको 10 मिनट में बता दूं, शायद इतना ही समय मुझे मिलेगा। तो सबसे पहले तो ये है कि 170 देशों में कमोडिटीज की ट्रेडिंग होती है। कमोडिटीज यानी कि जो हम खाते हैं और जो आपके आसपास है, यानी कि मिनरल्स, अर्थ जिसका सोर्स है। जैसे कि आप सभी लोग चिकन खाते होंगे, एग खाते होंगे, या सोयाबीन खाते होंगे, वेजिटेबल्स खाते होंगे। तो मैं एक एग्जांपल देता हूँ आपको कि चिकन का हम दुनिया में सबसे कम खाते हैं, 4 या 5 ऑन एवरेज। इजराइल 713 खाता है, 713 पर कैपिटा। और बाकी इसमें और आंकड़ों में नहीं जाऊंगा, तो आपको गूगल पे सारा मिल जाएगा। लेकिन जो कमोडिटीज की ट्रेडिंग में जो दो शाम खाना हम खाते हैं, 170 देश इसकी ट्रेडिंग करते हैं। अमेरिका में 20 कमोडिटी बोर्ड्स हैं, जैसे हमारे यहाँ 2 है, एक एनसीडेक्स और एनसीएक्स, और नेपाल जैसे देश में 4 है, यूरोप में 19 बच गए, 20वां बंद हो गया, लेकिन हमारे देश में सिर्फ 2 है। सबसे बड़े उत्पादक हम हैं, सबसे विश्व में सबसे अधिकतम किसानों की संख्या हमारे यहाँ है, सबसे ज्यादा तरह के क्रॉप्स हम उगा सकते हैं, 590 तरह की वैरायटी के क्रॉप हम उगा सकते हैं। लेकिन 2-3 पुराने एक्ट हैं, और उन एक्ट से पता नहीं या तो हम कोर्ट को नहीं समझा पाते हैं, ऑनरेबल जजेस को और ऑनरेबल एडवोकेट्स को भी, और आपको भी, और ये खास करके जो यंग एडवोकेट्स हैं उनको, कि है मर्ज कहाँ है। बिग एसेंशियल क्वांटिटीज एक्ट है। अगर आप 5 किलो अनाज का मतलब है कि अगर आप धान या गेहूं या चना या सोयाबीन, जो शेड्यूल्ड क्वांटिटी, शेड्यूल्ड 22+1 23+1 एक गन्ना है, अगर आप 5 किलो लेके एक राज्य से दूसरे राज्य की सीमा में घुसेंगे 5 kg, तो आपके ऊपर स्मगलिंग एक्ट है, यूआर स्मगलर। देश में 14 करोड़ किसान हैं, मैं आईफोन अगर मैं आटा लेके चलूं कोई कानून नहीं है, राइस का पैडी से हस्क ऊपर से निकाल दूं मेरे ऊपर कोई कानून नहीं। लेकिन मैं फार्मर हूं, मैं अपना अनाज अगर भारत में, मान के चलिए कि मैं दिल्ली का किसान हूं, वैसे तो मैं दिल्ली का नहीं, मैं बिहार का हूं, तो मैं बिहार से जैसे ही टपूंगा उत्तर प्रदेश की तरफ, तो मेरे ऊपर बड़ा आराम से आप स्मगलिंग एक्ट आपके एसडीओ साहब लगा सकते हैं। और जब उस एसेंशियल कमोडिटी एक्ट को खत्म करने की बारी आती है, कानून बनता है, पूरे देश में पता नहीं एमएसपी एक डिबेट शुरू हो जाती है, रिटॉरिक शुरू हो जाती है। एक ऐसा एक वर्ग है जो चाहता है कि हम लोग गरीब रहें और असमानता फैलते रहे, कोर्ट पे केसेस आते रहे। ये एक बड़ा मुद्दा है जो ओडीआर से थोड़ा अलग है। ओडीआर में उतनी संख्या ही क्यों बढ़े, उतने केसेस ही क्यों बढ़े, केसेस कम कैसे, हम लोग इसके बारे में सोचें। सबसे ज्यादा केस गांव से आते हैं। हर गांव में जाएंगे तो अभी भी आपको लोग चौराहे पे घूमने जाएंगे, कहाँ जा खड़ा रहो, चाय पिए, कहाँ, कोर्ट के पास, ये हमारे यहाँ का लैंग्वेज है। और वो सारे जगहों पे, जैसे इलाहाबाद जाए वहाँ आपको हर दूसरे घर में एक जज मिलेंगे, जज साहब मिलेंगे, प्रत्येक घर में आपको 2-4 वकील मिल जाएंगे। तो जो सोसाइटी तीसरी चौथी पीढ़ी पढ़ी हुई है, जैसे इलाहाबाद में या बंगाल में है, आपको वहाँ जजेस बहुत मिलेंगे। सबसे अच्छा प्रोफेशन और नोबेल प्रोफेशन एडवोकेसी कहा जाता है। लेकिन वो एडवोकेसी करते करते वो 170 देश के जो कमोडिटी ट्रेडर हैं, जो शिकागो बोर्ड ऑफ ट्रेड वाले हैं, जो यूएन सेंट्रल का एमओयू तैयार करते हैं, और हमारे पीढ़ी को बताते हैं कि आप अपना एमओयू ऐसा ही रखिएगा, इससे फुल स्टॉप कमा जहां चेंज किए, वो तो कन्वेंशन है, दैट इज नॉट लॉ, वी डोंट हैव टू फॉलो दैट, दैट्स अ कन्वेंशन। बट ऑनरेबल जजेस और ऑनरेबल कोर्ट विल ऑलवेज फॉलो दोज नॉर्म्स, those international laws. There are no international laws, they are just conventions. They are just conventions. It's all national interest. मेरे नेशनल इंटरेस्ट में नहीं है, मैं अपना चावल आपको नहीं दूंगा, आप क्या कर लीजिएगा, आपको देना पड़ेगा। आपके WTO में और उसके बड़े अजीब से लॉ हैं जो कुछ एक लोग जानते हैं, कुछ एक ट्रेडर्स हैं। तो शिकागो बोर्ड ऑफ ट्रेड बैठ के तय कर देगा कि आपके यहाँ का इन्फ्लेशन क्या होगा, आपको जो करना है कर। कौन सा ओडीआर इसको समझाएगा? तो ये हमें eVarta के माध्यम से और अविनाश जी और आप सबके माध्यम से पूरे देश को समझाना होगा, पॉलिसी मेकर्स को समझाना होगा। मैं यही काम करता हूँ। तो हमारी कमेटी का मैंडेट यही है कि हम 3 काम करते हैं। प्रधानमंत्री जी ने हाई पावर कमेटी बनाई, जो उन्होंने कहा कि हम समझा नहीं पाए, और अभी हमारे साथ प्राध्यापक महोदय बैठे थे, उन्होंने कहा कि 3 काले कानूनों को, उसको पहले काला कहा गया था, पता नहीं उसका रंग कैसे काला हो गया, इसलिए तो हम सिर्फ मैंने काला कोट नहीं पहना हुआ है, सभी लोग ज्यादातर लोग काले कोट में नजर आ रहे हैं, जैसे जो। तो वो 3 कानून जो बने थे हमारे भले के लिए, उसमें कुछ भ्रांतियां थी, उन भ्रांतियों को दूर किया जा सकता था, लेकिन वो वापस लेना पड़ा क्योंकि ये कार्टेल था, और वो कार्टेल जानबूझ के रोड पे बैठा था। आप तो आज का दिन बड़ा अच्छा है, उस कार्टेल का समापन हो गया। उस कार्टेल का समापन हो गया, एक जोरदार ताली मिलती है। थैंक यू वेरी मच। मैं डर रहा था कि ये पॉलिटिकल टॉक मुझे नहीं करनी चाहिए, लेकिन मैं तो सिविल सोसाइटी से आता हूं, तो मुझे कोई खास फर्क पड़ता नहीं। वो एक कार्टेल है जो कमोडिटी ट्रेडर के तरफ से और फर्टिलाइजर की लॉबी जो डीएपी, यूरिया, रॉक फॉस्फेट, जो एक डोमस ट्रस्ट करके आप लोग लिख लीजिएगा, डोमस ट्रस्ट, DOMUS, हम 2.5 लाख करोड़ रुपए फर्टिलाइजर की सब्सिडी देते हैं और 171 कंपनियां हैं जो फर्टिलाइजर हमको देती है। आपको जानकारी 5, 7, 10 की हो पाती है। तो दुनिया में जैसे ये माइक है, मेरा फोन है, वो प्लास्टिक की बोतल रखी हुई है वहां पे, उसको बनाने में भी नाइट्रोजन का खर्च यानी यूरिया लगता है, तो बड़ा डाइवर्ट भी होता है, बड़ा कॉम्प्लेक्स विषय है। कभी और आप हमको मौका दीजिएगा तो मैं आपको डिटेल आधा घंटा बताऊंगा इस बारे में, अभी उस तरफ नहीं जाता, सिर्फ आपको इतना ही बताता हूँ कि सब कुछ ट्रेसेबल हो जाए, ब्लॉकचेन लगा दें, ब्लॉकचेन तो लगा देंगे, लेकिन ब्लॉकचेन लगाने वाला कौन होगा, वो टेक्नोलॉजी कहाँ से आएगी, अंकल सैम देंगे क्या? अंकल सैम नहीं देंगे तो फिर ये हो क्यों रहा है हमारे यहाँ? मैं आपको और कुछ बताता हूँ जिससे आप समझेंगे। 2 चीजें बताता हूँ, उसके बाद फिर आपके प्रश्न आएंगे तो मैं बोलूंगा। दवाई में काफी बोलता रहूंगा, आप सुनते रहेंगे, अच्छा रहेगा आपको, लेकिन समय की एक सीमा होती है। पहला एग्जाम्पल ये है कि आप सब मिनिमम सपोर्ट प्राइस को बड़े अच्छे से समझते होंगे, सुनते होंगे, अखबारों के माध्यम से पढ़ते होंगे। 1 हेक्टेयर जमीन जो होती है उसमें 3.9 बीघा होता है। क्योंकि मैं बिहार से हूं तो बीघा की बात करूंगा। 1 बीघा में 20 कट्ठा होता है, बराबर। 1 हेक्टेयर में 3.9 बीघा होता है। सोयाबीन अगर आप मध्य प्रदेश में लगाते हैं 1 हेक्टेयर में, तो आपको लगभग 1650 किलो, 1650 किलो के आसपास का उत्पादन होता है 1 हेक्टेयर, जो कि 3 महीने की फसल होती है, 3 से 4 महीने का उसका मैच्योरिटी पीरियड होता है। तो MSP पे जोड़िएगा तो आपको लगभग 90,000 रुपए के आसपास आएगा। बढ़िया फसल अगर होती है तो, है ना, एकदम आइडियल कंडीशन में 80,000 रुपए, 90,000 रुपए 1 हेक्टेयर। उसके उत्पादन में जो कॉस्ट आता है उसके हिसाब से MSP कैलकुलेट। अब देखिए क्या रहा है, जो आपसे मैं चाहूंगा कि आप मुझे भी बैलेंस करें अगर मैं गलत बोल रहा हूँ। करीब 29 फैक्टर्स हैं जिसमें से एक फॉर्मेट बना है, उसके अनुसार हम डेटा कैप्चर करते हैं। तो 19 जगहों पे पूरे भारत में 19 इंस्टीट्यूशंस होते हैं, वो 14,440 फार्मर्स का सर्वे करते हैं। अभी तक करते आ रहे थे, अभी भी करते हैं। तो उसमें क्या है कि हर एग्रो-क्लाइमेटिक जोन में हमारे यहाँ 75 उसमें पॉइंट चूज किए जाते हैं। हर एग्रो-क्लाइमेटिक जोन से वो 75 जो पॉइंट चूज किए जाते हैं यूनिवर्सिटी के घर, उसमें 75 ग्राउंड चूज किए जाते हैं और हर जगह से 20-20 किसान दिए जाते हैं। तो ये संख्या घूम जोड़ के 14,440 आती है। आप सब हिंदी समझते हो, मैं अंग्रेजी भी बोल सकता हूँ और भाषाएं भी आती है, लेकिन हिंदी में थोड़ा मजा आता है बातचीत में। तो 14,440 किसान में से गुजरात एक ऐसा राज्य था जिसका सर्वे कागज पे नहीं टैबलेट पे किया जाता था। ये घटना घटी थी, दुर्घटना 2022 में। आप सोचिए, मैं लखनऊ में बैठा हूँ और मैं बाराबंकी का एक किसान का सर्वे बैठ के वही कर दिया और अच्छा खासा पैसा सरकार उस सर्वे को करने को देती है, एक पूरा डिपार्टमेंट है इसके लिए। तो 60 साल से 65 साल से आप झूठ बोल रहे थे। अच्छा चलिए, डेटा कैलकुलेट करके, तो डेटा कैलकुलेट करने के बाद सारा उसमें करने के बाद एक सॉफ्टवेयर होता है फॉर्मेट, और फॉर्मेट 2.0 है। फॉर्मेट 2.0 FAO ने हमको दान में दिया है। FAO आप समझते हैं ना, फूड एंड एग्रीकल्चर ऑर्गेनाइजेशन, यूनाइटेड नेशन की ऑर्गेनाइजेशन है जो खेती बाड़ी में सारा काम करती है, ठीक है। उनके अंदर CGI इंस्टीट्यूशंस आते हैं, पाए जाते हैं, उनको नीली गाड़ी, नीला वाला मिला हुआ है, डिप्लोमेट ले जाते हैं, काहे के डिप्लोमेट मुझे अभी तक समझ नहीं आया। CGI इंस्टीट्यूशन की सेट कहाँ से, अगर FAO नीली पट्टी लेके घूमे, या FAO से कोई भी लग जाए, कल को आप IAS को लगा दीजिए तो हमें भी नीली पट्टी मिल जाएगी, सारे एडवोकेट्स को दे दीजिए। तो ICRI SAT, IRI, इस तरीके के कई इंस्टीट्यूशंस हैं जो हमारे फूड पैटर्न को तोड़ने के लिए 67-68 के आसपास बनाए गए, जिनको हम पैसा देते हैं, उनको हम ही पैसा देते हैं और हम ही उनसे फिर चलिए। तो फॉर्मेट 2.0 यानी कि हमारा जो भी डेटा है वो तय करेंगे उस सॉफ्टवेयर के हिसाब से। तो हमारा तो कुछ रहा नहीं, जब आपने डेटा दे दिया गांव तक का, एक खेत का, जो भी आपके पास था, उसके हिसाब से सारा काम होता है। दूसरा, प्लास्टिक की बोतल आप लोग उठाएंगे, उसमें GI नंबर होता है, जो भी सामान उठाएंगे उसमें बारकोड होता है। GI नंबर का सर्वर कहाँ है आप बता सकते हैं? थोड़ा और कोशिश कीजिए। चलिए मैं क्लू देता हूं, वहां पे 130 साल पुरानी संस्था है जिसको इंटरनेशनल कोऑपरेटिव अलायंस है। ये इंटरनेशनल कोऑपरेटिव है। और बताइए कहाँ है? वो यूरोप में, इतना मैं आपको हिंट कर रहा हूँ, ब्रुसेल्स। ब्रुसेल्स एक जगह है जहाँ पे वो सर्वर रखा है, बराबर। तो दुनिया में जो भी आप कंज्यूमर बिहेवियर है, एक जगह सर्वर रखा हुआ है, वो सारा काम डिसाइड कर देंगे कि आप आईफोन आप रखते हैं, उसमें बारकोड क्या है, क्या समस्या है। तो ये जो एक डिजिटल इनइक्वालिटी है जिसके ऊपर हम नहीं जानते हैं और हम सबसे बड़े कंज्यूमर हैं, तो हमको थोड़ा इस तरीके से भी सोचना होगा कि जो हम डेटा हमारा ODR में और तमाम चीजों पे कोर्स का डेटा है वो हमारे लिए कितना प्रोटेक्टेड है। यूएस का डेटा एक्सेस नहीं कर सकते। यूएस में जो एडवोकेट साहब वहाँ होंगे वो क्या करते हैं, उनका डेटा वो तो आप आजकल चैट जीपीटी में सब डालिए, सब आता है, लेकिन वहां का जहां केसेस का लिस्ट डालिएगा उसका कोई ब्रीफ नहीं आएगा। सजेस्ट मी 10 cases concerned with UN CITRA where the decision has been given, with reference to such and such. Chat GPT will say 3 लाइन में उसका आंसर आ जाएगा, कुछ आएगा नहीं। हमारे यहाँ दीजिए तो कम से कम 30 पेज में आंसर आ सकता है। ठीक है, तो हमारा तो सब कुछ फ्री है, उनका सब कुछ फ्री नहीं है। तो डिजिटल इनइक्वालिटी इतनी बढ़िया जो विश्व में बनी हुई है, इन सारे विषयों के बारे में सोच करके और टेक्नोलॉजी का जिस तरीके से हमको प्रयोग करना है, क्योंकि अल्टीमेटली करना आपको ही है, युवकों को ही करना है। हमारे को, हम लोगों की तो उम्र हो रही है, हम लोग तो दूसरे तरफ जा रहे हैं, वानप्रस्थ आश्रम में जा रहे हैं। तो आप जैसे जैसे इसके लिए एम्पावर होंगे और केसेस लड़ेंगे, कोर्ट्स को समझाएंगे कि अगर एग्रीकल्चर का इंस्टीट्यूशन है वो एंटी पुअर लॉबी एक काम करती है इस देश में, जो उस एग्रीकल्चर इंस्टीट्यूशन को बंद करवाने के लिए कोर्ट्स का इस्तेमाल करेगी। तो जज साहब तो डिसीजन वही देंगे जो आप बोलेंगे, जो आप बात रखेंगे। और आप बात कहां से लेंगे? गूगल दादा से लेंगे या चैट जीपीटी से लेंगे। तो आपको जो रियल इंफॉर्मेशन, जो रियल रिसर्च है, उसके लिए जो कुछ भी चाहिए, अगर मान के चलिए जैसे 1 किलो, जैसे एक्सपोर्ट प्राइस, जो मिनिमम एक्सपोर्ट प्राइस जो बड़ी मुश्किल से हम लोगों ने लगवाया हुआ, उसमें मिनिमम एक्सपोर्ट प्राइस पूसा बासमती 1121 का $750 प्रति एमटी। कितना हुआ $750? $66 प्रति किलो, 66 रुपीज प्रति पर केजी। कौन सी स्केल ऑफ इकोनॉमी है? 66 रुपीज पर केजी में वो जेद्दा पहुंच जाती है या यूएस के पोर्ट पर पहुंच जाती है। हमको समझ में नहीं आया, हम लोग तो नहीं समझा पाए, तो हम लोग बड़ी मुश्किल से इसका $750 से कहा अपने माननीय कॉर्पोरेशन मिनिस्ट्री को कि आप इसको $1200 दीजिए। और कोर्ट में केसेस लग गया एकदम। लोग तुरंत रात में, शाम में 5 बजे आया, सुबह एकदम रजिस्ट्रार साहब खोल के कोर्ट में केस लगवा एकदम 9:30 बजे केस फाइल हो गया। 30 स्ट्रॉन्ग ऑर्डर, हालांकि ऑर्डर वो नलिफाई नहीं करवा पाए, अभी भी $900 है। लेकिन उस किसान के बारे में सोचिए कि अगर 66 रुपए वो जेद्दा पे जाता है, उसको उसका 25 रुपया या 30 रुपया मिलता हो, और फिर हम उसको और भी तरह की यातनाएं देते हैं। तो इन कई चीजें, ऐसे कई सवाल मेरे जहन में है, कभी खुल के हम लोग और दूसरे प्लेटफॉर्म पे बात करेंगे। लेकिन इस वैल्यू चेन को, एग्रीकल्चर वैल्यू चेन को, जो रूरल वैल्यू चेन है और जो फार्मर सेंट्रिक नहीं है, जो एडमिनिस्ट्रेटिवली इम्प्लीमेंटेबल नहीं है और जो इकोनॉमिकली वायबल तो बिल्कुल भी नहीं है और इन्वायरमेंटल सस्टेनेबल है ही नहीं, क्योंकि जहां चावल होना चाहिए वहां चावल होता नहीं है, जहां चावल होना चाहिए वहां नहीं होता है, और जहां नहीं होना चाहिए वहीं होता है। फिर वाटर डिस्ट्रेस, ये समस्या, वो समस्या। आज की तारीख में अगले 6 महीने में जो डिस्ट्रप्शन आने वाला है, 750 CIA एजेंट्स को गोल्डन हैंडशेक दे दिया गया है। WHO से यूएस बाहर निकल गया है। यूएस एड के 100 कंट्रीज में जो ऑपरेशन होते थे बंद कर दिए गए हैं। तो आप सोचिए कि अगले 6 महीने में जो डिस्ट्रप्शन होगा, उसके लिए, उस जियो इकोनॉमिक और जियो पोलिटिकल सिचुएशन के लिए हम ODR के माध्यम से अपने सिटीजन्स को क्या दे सकते हैं, क्या कर सकते हैं, आपस में एक दूसरे के साथ सहकार कैसे कर सकते हैं। मैं चाहता हूं कि आप सब लोग मिलजुल करके, मैं विनाश जी से भी आग्रह करूंगा कि एक एडवोकेट्स का मल्टी स्टेट कोऑपरेटिव बने, जिसमें एक उसका उस इकोनॉमिक फ्रेमवर्क में काफी बिजनेसेस हैं और उसके बारे में उसका जो भी सपोर्ट सिस्टम या एक वार्ता जो आपके साथ डायलॉग हो सके उसके लिए मैं करने के लिए तैयार हूँ कि कैसे वो प्रॉफिटेबल होगा। अदर कंट्रीज में है, जर्मनी में है, हम लोग भी कर सकते हैं उसका, जिसका आपको बहुत फायदा मिलेगा उस एंड में जो अभी अपना कैरियर शुरू कर रहे हैं। थैंक यू वेरी मच। जय किसान, जय हिंद, जय श्री।
Our next speaker, Advocate Dr. Yashpal Sharma. Sir is a retired Joint Director from Ministry of Home Affairs, Government of India. He currently practices mediation at the State Consumer Dispute Redressal Commission in New Delhi. Dr. Sharma holds a PhD from Rajasthan University and is a prolific author. Today he will bring his wealth of experience in mediation and dispute resolution to our discussion. Sir, I welcome you.
Thank you very much, Honorable Vijay Sir, and two of my teachers, Dr. Shilpa Babade and Dr. Sen, very distinguished teachers, and my friend Mr. Yogendra ji, Anand ji, and all dignitaries there at the dais, and my good friends, those who have been listening very carefully. बजा दो यार। रुको क्यों? Nice thing Mr. Anand was telling that, and he says that I'm an advocate, and he didn't wear a black coat. He's been telling like that. Anyhow, I'll talk about mediation. I wanted that our friend who is a mediator in Supreme Court and he has a vast experience, that is Mr. Indyal. I wanted him to speak first. So I'll take only 2-3 minutes because we have been we have been deliberating this concept for last many days. What is ADR, what is ODR, and what exactly are the tools of that, how commercially that can be used. I mean, our main purpose is, I tell you, after a few decades, maybe 1 or 2, not more than that, we won't find files in the courts. That is my gesture. We won't find any file here. Reason being, when we were studying the cyber law, so Sir told us that it is 10A, and Dr. Shilpa Babade also, that 10A is the section which was converting all manuals into the electronics. And though I am a mediator there in the State Consumer Commission and done a lot of degrees and everything, but I still say that mediation is a good way, because I won't speak much today. And also the new Mediation Act, if you have read that, if you have studied that, that is very, very useful for you, for advocates. We have, earlier what we have been doing, when this Consumer Protection Act was being designed, I was a party to that. And I found that section 74 to 81 was kept for mediation. Earlier in the earlier act, there was no mediation at all, as far as consumer is concerned. And now I went into the court, and court associated with mediation I have done. I'm a mediation charge over here. And I found that mediation is a way, what exactly to my mind? How can be a useful mediator use his talent over there to mediate the things? How he can do it? He must have all the 7 lamps of advocates first. You'll be studying that what are those 7 lamps? That is honesty, courage, wit, intelligence, and all these things. You must have these things. In the new act, earlier we have taken the cases according to the 1986 Act, but now in consumer we start taking this 2019 Act. as far as this act is concerned, Dr. Shilpa Bogadi has been telling about the international mediation. That is one of the item there, one of the topic there, one of the subject there, one of the object there. It is there. Institutional mediation, collective mediation. We have this. And section 4 gives you the mediation agreement. I mean, mediation cannot be done without any agreement. There should be an agreement between both the parties. I won't go into the detail because I know Alisa will be just telling you all the details of this thing. And then it is a pre-litigation also. What is a mediation? I was asking this thing. Mediation is, I read a book when I was doing MA economics. In that book there was welfare economics. And one line was given that what is the welfare? What is welfare? Making A better off without making B worse off. A को फायदा हो जाए, B को नुकसान ना हो, ये कल्याण है. और कल्याण का दूसरा नाम मेरी नजर में मीडिएशन है. जब मैं मीडिएशन के लिए बैठता हूँ, जब मैं मीडिएट मैंने कम से कम 100 से ऊपर केस मीडिएशन के हल करे हुए, उसमें मैं यही सोचता हूँ कि A को नुकसान ना हो, B को फायदा हो जाए, B को नुकसान ना हो, A को फायदा हो जाए. लेकिन दोनों विन विन सिचुएशन में हो, ये एक न्यूट्रल मीडिएटर का फर्ज है. इसलिए सेक्शन 6 जो बोलता है, एक्सेप्शन बोलता है. क्या कहता है? It says that there are certain exceptions. Criminal cases, no mediation. Only it could be there in the matrimonial cases. It could be there in the consumer cases. It could be some community affairs also. Small cases, I mean less money, it can be. Now there should be no conflict of interest. I won't go into the detail. I know that at least having all these things, my friend. So Mediation Act has been giving a lot of things, things about the mediation which are very beneficial. And I tell you, in long run, this mediation, because India is what? First of all, I know if somebody from ILI, I think 10, 12 years ago, I wrote a project in India. And the subject of that project was ADR in Mahabharata and Ramayana. So many people like that. I wrote that Krishna was the biggest arbitrator. I wrote over here. Anyway, it was my personal view. Might not be everybody agreed to that. And thereafter, I gave that how negotiation could be done. Negotiation is a different thing than that of the mediation. Suppose I go to a hotel and in the room I find that something is broken. So they said no issue. When I came to the counter for my bill, they just charge something. They charge suppose 2,000. I say that let it be 1,000, let it be 500. So that is a sort of negotiation. And there are other things is conciliation and arbitration. These four things are there. Mediation is the most important thing in that. I mean now the government has given 120 days for mediation. Earlier what happens, people go to the mediation and just kill the time for 6-7 months together. But now the government has allowed, this act has allowed us 120 days, even extra 60 days could be given over there in this new act. So I won't go to too much detail, and I know that we are talking on online dispute resolution, and I know that this online dispute resolution is going to enhance ADR, as Dr. Bogade also said that ANSIPRAL and all these agencies, they have been giving ease to that. and Dr. Anand also, he told that we can even put into that and it can be commercial also. So, the children, I will call them children, that is Vishwali and Abhilash. So I would like to invite Vishwali for
Sir,
1 minute.
conclude, please. Conclude, please.
Eh?
Please conclude.
I'm concluding, sir.
Yes, please.
I'm concluding. So, Dr. Murali, I think you gave me this topic which I was talking about. You remember? 12 years ago. Sorry, sir, I couldn't see. And thank you very much. Hopefully, I think I have concluded my thoughts. Thank you.
Indeed, the topic is so serious and so pressing that we want to listen to many people for a longer period. But because of time constraint and the second session is also knocking the door, therefore I have requested you to conclude. I know you have done a very good job. I may also request other speakers in this session and the other session that the inaugural speech has identified 5 issues. So if we can focus on those 5 issues, this whole endeavor by Avinash and the university will be more useful. Let me reiterate these 5 issues: legal policy and framework, how to improve it; technology and AI, Professor Anand is going to identify, going to give this speech; obstruction in ODR, what is the obstruction? How to address digital illiteracy; ability of the small business, is it available to small business also? How to do it to those who are non-tech savvy; and incentives to business and future of business. 5 or 6 issues have already been identified by the learned inaugural speaker, Professor Sunanda Bharti. So I will request everyone in this session and the next.
And insights. Thank you for being such a fantastic speaker.
Our next speaker, Dr. Anand Singh, is an assistant professor at the Faculty of Law, Delhi University. He holds an LLB from Campus Law Center, an LLM from the Indian Law Institute, and a PhD from Dr. Ram Manohar Lohia, National Law University, specializing in taxation law, cyber law, and IPR. Today, he will discuss the role of AI in ODR. Please welcome Dr. Anand Singh.
Thank you. It's a rather privilege to be over here and discuss upon something which is relevant. I really jotted down the understanding and the points which Professor Sunanda brought to the understanding. Looking into the vast experience and the concerns over here, that as a human being, will AI be succeeding? Will AI be able to do it? Before going ahead, we look into it. Okay, can anybody thought of that? When and what is the reason behind the term artificial intelligence? That today we talk about artificial intelligence, which is certainly somebody desires to have an understanding. Seriously, I would like to have something that I must be somewhere updated with each and everything. But am I able to update it? No, I am not able to. So that means human intelligence has certain constraints. Constraints of a memory. Just imagine your memory could be doubled, tripled, multiplier of thousands. Will we not be happy as we will be the best person over here to answer each and everything? If I ask respected my fellow friends that which was the case which yours happened to be the 10th in your professional career, you're going to be saying, sir, I will have to look into my case study. And what is something that I gave you some understanding that now you can have access to it, and it's going to say this was the 10th case, this was the provision, and this was the judgment, and these many dates I have taken up, and ultimately my case was on my side within this particular timeline. This is what we are looking into it, the comparable understanding. The comparison has been ever since when you talk about the communication. Ultimately, when you talk about AI, we are not talking about the technology. We are understanding many things. The genesis of the entire IT, artificial intelligence, everything, the founding has been based on a principle of a data. That means what to feed across and which way to get it through the processing, is it reliable or is it not reliable? That is where we have to perceive it. For this, let me just start my understanding and share across. In 1956, not now, 1956, a small group of scientists gathered for the Dartmouth Summer Research Project. Let me emphasize, it was a summer research project on artificial intelligence, which was the birth of field of research. And it was by John McCarthy, Dartmouth College, M.L. Minsky, Howard University, and Rochester IBM Corporation, and C.E. Shannon, Bell Telephone Laboratories. When they looked into this particular understanding, they never thought they were going to be working on something AI and we're going to be replacing it up. They were talking about the communication, challenges, and improvisation on this particular understanding. So when we look into these particular things, it comes up, now we have an AI, why not look into it? We are using it up. If I ask over here, and I'm open, because we all are professionals, if you have to carry on a research, which is a necessity element of each and every professional life, will be how much reliance you're going to place upon Google as compared to Westlaw, as compared to JSTOR, as compared to Hein Online. What will be the ratio? So Google will not go. It gives a lot of results. Will you rely on Wikipedia? I will get an answer negative over here because of our data being fed. But let me tell you, United Nations and UNCTAD report, they highlighted the data which was fed upon Wikipedia available in UNCTAD reports. So we need to beware this AI, when we look into it, how it's going to be looking into it. ODR or EDR, is there a distinction? In India we talk about ODR. Ultimately, is it ODR can I say, or ultimately it should have an answer like EDR? Because there is no O-commerce, because online dispute, there is e-commerce. If at all it is e-commerce, what was the genesis about having e-commerce or the E alphabet over here? It was EDIFACT, Electronic Data Information for Administration, Common and Transport. Then they looked into it. United Nations was looking into it, that they desired that somewhere compatibility of the technology is required. So they infused this particular technology using the e-commerce as the key word and a key term. When they use this e-commerce, now we look into it, so role of AI, human intelligence, how we're going to be looking into it and what are the challenges, how we perceive it up, and these things come up. So the objective of AI was only to emulate human cognitive and decision-making capabilities, focusing on problem solving. Now if I ask, how many of us are using AIs? Almost everyone. Almost everyone. But now my question majorly and primarily, are you 100% placing a reliance on this particular data? Because I take it up, if I take up a disease, which is certainly of serious nature, a doctor says, okay fine, this was my 10 years of expertise, and I feed upon this my data. So can I say that 10 years of data of treatment of a particular critical illness will certainly give you a solution to treat the patient in new age? Answer is no. So that is where the concern, Professor Sunanda rightly said that how far dependency should be there. Right now the AIs which we are using up happens to be weak systems. So question comes up, should we have a weak system or should we have a strong system? One thing keeping in mind, if AI we talk about, we have a strong system, it is a replacement to a human. Now we go ahead that if it is a replacement to a human, will it succeed in the times and challenges? Answer is no. So that means when we look into it, why there is a lot of understanding and debate going around this AI as part and parcel, and what role can it play with respect to ODR. When we look into this ODR, there have been technologies, automated, repetitive and predictable tasks, freeing up their human resources to focus upon the complex and nuances issue. Now if you talk about, sir, then what is the understanding why we are looking into AI as a resourceful mechanism in mediation, in arbitration? I can feed it upon this particular data. I can tell them, okay fine, these are the cases which should be streamlined with respect to only corporates. These are the cases which fall within the ambit of ADR, saving up on the time, which shall be marital dispute.
These are the customers, so I must appoint another officer as a supervisor who's going to be coming with the resolution. These are intricacies directly infringement or somewhere the law has been violated, so it can't be looking into it. Taking an example, supposedly a Mr. X jumps off the red light. It's simple, 500 rupees fine, ask him over there if you would like to contest. He can go and he can look into the virtual code. Can I say it is an ODR mechanism? Answer is yes. Have you followed it in the Indian system? Yes. Is there a limb? Yes. Is there a network? Yes. We are placing a lot of reliance on these particular systems. And these are nothing but these are AI based. We are very much conversant that we find there are cameras, but how much of us know that these cameras actually can detect a facial recognition as well? In Bangalore last year, November, there has been a case which has been solved only through use of AI, a facial recognition running across the data. Is it not a success? Yes, it is a success. So entire reliance, when we look into it, and the challenges being come across over here is, most importantly, ensuring privacy and data security. That's it. Okay, fine, we have to feed the data to AI, then only it will process the data. So what is the privacy over here? What are the concerns? Balancing the automation and human intervention. That means how far should we rely upon the automation and how much human intervention is necessary. These are somewhere modalities which are to be seen, which are to be triggered, and ethical consideration. That means, so there has been a loss of life. How to deal with it? We have to look into the instances. For loss of life, we look into the gravest of grave. Then what are the scenarios, how to decide it up. So can I rely totally on the automation? No. These are the things which I have to look into it. For which now, most importantly, for an AI to be looked into it, it should be data curation and analysis. That first of all, what you feed across the data must be observed, must be seen, that what kind of data we are looking into it. I'll take an example. AI was being used and it was brought into during the course that we find how it's going to come up. The data was being processed in US to decide upon a case and the facts were being given. The output result came up. It was worthy of the times when the judgment had come up. Judgment came up in 1950s somewhere. And what was the outcome of the judgment? It was somewhere looking into being harsh towards black, and that is why the outcome was, okay, fine, the blacks will be punished even right now. So will you rely on this data? It requires a collection of organizing of data pre-processing, exploratory data analysis. So these data, that means what you feed upon is being processed and is being given back to you, and that is where you have to rely. That can be as humans be placing a reliance upon it. Then addressing potential biasness. Okay, fine. If I take a particular act, motor vehicle act, rational negligence act, that is somewhere run accident where deaths have come up, I process that particular data, and that accident has taken up before the ambulance. Should it be the same thing? Answer will come up same. So wherever rational negligence act has been there, fine. So the punishment will be looked into it. But if it was an ambulance of no fault of theirs and life has gone, who's liable? So that means a human is required, and that is where potential biasness has to be identified. Mitigating biasness is the another one, and monitoring for biasness is again the scenario, because in our courts also likelihood of biasness amounts to biasness per se. Then fine-tuning algorithm, that is model selection and training. Then other are requirement. So what is need? What is the solution to these particular problems? It is a collaboration between AI experts, legal professionals, and consumer protection agencies, which is vital for designing AI systems that cater to the unique requirements of ODR and addresses the concern such as privacy, data security, and ethical consideration. So when you look into it, AI has come across a long way. For instance, the best example which I can look into it is the chatbots, if you look into it. So for chatbots, when you look into it, how it can be a module that could answer you in a frequently asked questions. One is, we pre-classify the claims. That means what kind of claims are coming up. I prepare it over there, that in case there is somewhere hit and run claims, it's going to be looking into this particular segments only. That means it will automatically be done. That means at the stage of filing cases, one, or at the time when we look into the ODR, they're going to come up, okay, fine, this will go to this particular department. These are the experts who's going to be looking into it. Secondly, we're going to use gathering the relevant information from the users, initiate the dispute resolution in process on behalf. That means you demand again the explanation, process it up, that what are the requirements. Then chatbots can also provide the users with the updates on the status of the cases. Chatbots provide the users with the frequently asked questions that will be helpful. So meaning thereby certainly we are relying on technology. The question over here, how far should we go? Should we stop at some level, or should we come up with the strong AI tools, or should we come with the weak AI tools is still on us to decide. But right now so far, yes, it is a need of an art. Why? Pendency of the cases, justice, and also the mediation outcomes are not something that could be appreciated. Thank you everyone. One thing before going ahead, I'm so happy and glad to share one thing that in 2023, Abhilash, Biswajit, Yashpalji, they actually thought, I believe out of them, Abhilash happens to be legal student at Law Center 1. Biswajit is a software expert, where his concern was what to do with respect to his software. He came across and he picked up this particular topic. A student picking up a topic for submission and marks. And then he take it up, that will find this is my topic, and he has given it a color and shape of a eVarta. And a round of applause not only to them but also Avinash taking it further, because this is within the span of 3 years I've seen somebody consulting and taking out their time and concluding in this particular project. Certainly those on the dignitaries, their efforts, motivation was always there. Thank you everyone.
We really appreciate you sharing your knowledge and expertise with us, sir.
Our next speaker is Yogi Makkar. He is Engineering and Planning Manager at Indian Oil Adani Gas Joint Venture, a mechanical engineer with an MBA. He brings over 18 years of experience in the gas downstream sector, specializing in project management, supply chain, utility management, contracts and process automation. His expertise in data-driven strategies for operational excellence makes him a valuable voice in today's discussion. We welcome you, sir, to provide our industry perspective on ODR Solutions.
Thanks for the introduction. First of all, I would like to thank Avinash for giving me a chance to speak here. And also, I would also like to thank ma'am, Sunanda ma'am. Like my wife is a student of your law college, so I am very happy that she is getting the right kind of education. So thank you very much for that. So मेरा जो टॉपिक है वो बहुत सिंपल है. जो मैम ने प्रॉब्लम एरियाज बताए थे, जो गैप्स हैं, ODR का वाइड एडॉप्शन नहीं हो पा रहा, उसके अराउंड में बात करूँगा एक इंडस्ट्री पर्सपेक्टिव कि इंडस्ट्रीज को क्या चैलेंज आता है. तो इसको ऐसे स्टार्ट करते हैं कि जस्टिस तो हमेशा से मिलता है, युगों से जस्टिस दे रहे हैं, बस एक तरीका चेंज हो गया, कोर्ट्स बन गए हैं उसको जस्टिस को देने के लिए. तो इसमें बेसिक जो फ्रेमवर्क है सारी चीजों का, वो एक फाउंडेशन लेवल पे होना बहुत जरूरी है. ठीक है, तो इसके लिए जो मेन इशू जो आता है वो कॉन्ट्रैक्ट्स में आता है. मेजरली वी आर फेसिंग इश्यूज इन कॉन्ट्रैक्ट. द कॉन्ट्रैक्ट्स आर नॉट रिटन प्रॉपर्ली, due to which major problems occur at a later stage. और arbitration clause बहुत सारी इंडस्ट्रीज फॉलो करती हैं, उनके कॉन्ट्रैक्ट्स में लिखा होता है. Then also they do not follow the arbitration route. तो ये एक चैलेंज है. ऑनलाइन डिस्प्यूट रेजोल्यूशन कॉर्पोरेट मैनेजमेंट में ऑफ कोर्स इसके बहुत सारे बेनिफिट्स हैं. एफिशिएंसी और कॉस्ट सेविंग होता है, ग्लोबल रीच है, स्केलेबल है, कस्टमर ट्रस्ट एंड सैटिस्फैक्शन बिल्ड करता है, एक्सेसिबिलिटी है, कन्वीनियंस है, न्यूट्रल है, और भी बहुत सारी चीजें हैं. बट जो मेन प्रॉब्लम है, जो मेन इशू है, जैसा सर ने भी बोला, इज अराउंड कम्युनिकेशन. communication, when I talk about communication, it is both written and verbal. तो जब कोई चीज़ कोर्ट तक पहुंचती है या फिर एक ऐसी जगह पे पहुंचती है जहाँ पे ऑनलाइन डिस्प्यूट रेजोल्यूशन जैसी चीज़ की रिक्वायरमेंट हो, तो वहाँ पे मेनली कम्युनिकेशन एरर्स ही हमें मिलते हैं, कॉन्ट्रैक्ट्स में मिलते हैं। तो इसके लिए जो इंडस्ट्री का जो सोल्यूशन हो सकता है दैट रिवॉल्व्स अराउंड स्मार्ट कॉन्ट्रैक्ट्स। कैसे हम अपने कॉन्ट्रैक्ट को स्मार्ट बना सकते हैं। Smart contracts are self-executing digital agreements stored on a blockchain. Online dispute resolution uses technology to resolve these disputes. In India, smart contracts are emerging as a key enabler of automated dispute resolution. जैसा जैसा ODR बढ़ रहा है, हम उसमें एक और स्टैटिस्टिक्स अगर देखेंगे तो स्मार्ट कॉन्ट्रैक्ट्स भी बढ़ रहे हैं। स्मार्ट कॉन्ट्रैक्ट्स को बनाने के लिए ऑफ कोर्स लीगल एक्सपर्ट्स की रिक्वायरमेंट रहती है बहुत ज़्यादा। हर लेवल पे ड्राफ्टिंग से लेके उसको एक इलेक्ट्रॉनिक फॉर्म में कन्वर्ट करने के लिए हमारे लीगल प्रोफेशनल्स की ज़रूरत है। तो जैसा सर ने बोला था कि क्या ये पूरा एक ऑटोमेटेड सिस्टम हो जाएगा जिसमें लीगल प्रोफेशनल्स की ज़रूरत नहीं पड़ेगी, मेरा पर्सपेक्टिव दूसरा है, इसमें ज़्यादा लीगल प्रोफेशनल्स की ज़रूरत पड़ेगी। क्योंकि बहुत सारे लोग ऐसे हैं जिनको डिजिटल लिटरेसी तो है बट लीगल लिटरेसी नहीं। तो लीगल लिटरेसी एक बहुत बड़ा पॉइंट है जिसके ऊपर फोकस करने की जरूरत है। काफी सारे इंस्टीट्यूशंस हैं जो इसके अराउंड काम कर रहे हैं, जैसे रिजॉल्व 360 है, आईसीआईसी बैंक ने इस पे काफी काम किया है, जो कि क्रॉस बॉर्डर ट्रेड एग्रीमेंट्स पे स्पेशली काम कर रहा है उसको इंप्रूव करने के लिए, और इसमें जो बैंकिंग रिलेटेड जो फीस होती है उसको रिड्यूस करने के लिए। क्योंकि बड़े कॉन्ट्रैक्ट में जहाँ पे बहुत सारे बिजनेसेस ग्रो करना चाह रहे हैं, आज की डेट में न्यू इंडस्ट्रीज आ रही हैं, एवरी ग्रुप वांट्स टू ग्रो, तो उस ग्रोथ में क्रॉस बॉर्डर ट्रेड एग्रीमेंट बहुत कॉमन है। तो उसमें जैसे मेजरली जो फाइनेंशियल इंस्ट्रूमेंट्स यूज होते हैं उसमें हाई वैल्यू बैंक फीस इन्वॉल्व होती है। अगर उसको एक ब्लॉकचेन में कन्वर्ट कर दिया जाए देन ऑफ कोर्स many costs can be reduced. For that conversion of a blockchain, a lot of legal expertise is required. आप सिंपली ऐसा नहीं बोल सकते कि ये एक लॉ है, इसको एक कोड फॉर्म में लिखो। किसी भी लॉ को कोड फॉर्म में लिखने के लिए बहुत मेहनत चाहिए, उसके पीछे बहुत सारे डेटा चाहिए, और इसका जो मेजर जैसे कि इसको हम ODR को हम मे बी जो डोमेस्टिक डिस्प्यूट्स है उसमें एक लिमिट तक नहीं यूज कर सकते, क्रिमिनल केसेस में नहीं यूज कर सकते, तो मेजर इम्पैक्ट जो आता है कॉन्ट्रैक्ट। तो हमें ये इंडस्ट्री जो ग्रो करेगी वो ग्रो करेगी अराउंड कॉन्ट्रैक्ट्स की बात है। जितने भी बड़े बिजनेसेस हैं, अगर हम अभी की बात करें, जो डेटा कहता है, जो नीति आयोग का भी डेटा कहता है, वो ये कहता है कि मेजरली जो इसका यूज हो रहा है वो ई-कॉमर्स के लिए यूज हो रहा है। यानी कि इट इज सिंपल केसेस, जैसे कि पिज्जा टाइम पे नहीं आया तो मेरे पैसे वापस कर दो, एक ऑनलाइन ग्रीवियंस रिट्रेसल है, आपने हेल्प में डाला और आ गया। और अमेज़न से आपने कोई पैकेज मंगवाया, वो टूटा हुआ आ गया या कुछ उसमें प्रॉब्लम आ गई तो आपने एक ऑनलाइन। बट क्या अगर इसको बढ़ाना है तो सिर्फ हमें इस इंडस्ट्री पे फोकस करना है? इसके अराउंड बहुत सारी इंडस्ट्रीज है जिस पे हमारा फोकस करना जरूरी है। इसमें फार्मा इंडस्ट्री है, कंस्ट्रक्शन इंडस्ट्री है, इंजीनियरिंग इंडस्ट्री है, बहुत सारी ट्रेडिंग इंडस्ट्री है जिस पे फोकस करने की बहुत ज्यादा जरूरत है। और फिर से मैं उसी पॉइंट पे आ रहा हूँ कि अगर इसको अच्छा करना है तो मैं एज अ इंडस्ट्री दूसरे किसी से कुछ सामान लेता हूँ, कुछ इंजीनियरिंग सर्विस लेता हूँ, कोई भी सर्विस लेता हूँ, तो मैं उसको एक कॉन्ट्रैक्ट में बाइंड करता हूँ। अगर उस कॉन्ट्रैक्ट की लैंग्वेज एक लीगल पर्सपेक्टिव से ओवरलुक कर दी गई है तो उसमें आगे जाके प्रॉब्लम आने की बहुत ज्यादा चांसेस है। अभी जो ODR adoption by industry की अगर हम बात करें तो I prepared a detailed presentation on this. E-commerce is using 40% of it. and 25% is being used by the banking and finance industry. Telecom is using only 15% of it. So जो मेजर इंडस्ट्रीज है उसमें तो ये बाकी में यूज ही नहीं हो रहा, ऑटोमोबाइल इंडस्ट्री में ये यूज नहीं हो रहा, कंस्ट्रक्शन में नहीं यूज हो रहा, एनर्जी में नहीं यूज हो रहा, एफएमसीजी में नहीं यूज हो रहा. It is very limited to small consumer related matters only. यहाँ पे टेक्नोलॉजी का रिक्वायरमेंट है और मेरा ये मानना है कि जस्टिस ओडीआर का पूरा जो व्यू है वो ये है कि केसेस कोर्ट में ना जाए, इट स्टेज आउट ऑफ द कोर्ट. बाहर ही आपका ट्रस्टवर्दी सिस्टम ऐसा बने कि जिसमें हम कोर्ट में जाने की जरूरत ही ना पड़े. एवरीथिंग शुड बी क्लियर, क्रिस्टल क्लियर होना चाहिए, ट्रस्ट होना चाहिए हमारे डॉक्यूमेंट्स. तो एज अ लीगल प्रोफेशनल हमारी रिस्पांसिबिलिटी सिर्फ ये नहीं है कि कोर्ट में जाके हम किसी अपने क्लाइंट को डिफेंड करें और चीज़ों को सॉल्व करने की कोशिश करें. हमारा मैटर ये भी होना चाहिए कि हम उसको प्रिवेंट करें कि वो कोर्ट केस के उसमें जाए ही नहीं. सो जस्टिस इज नॉट ओनली अबाउट रिजॉल्विंग डिस्प्यूट, इट इज अबाउट प्रिवेंटिंग देम थ्रू क्लैरिटी, फेयरनेस एंड अकाउंटेबिलिटी. In Mahabharata, when Lord Krishna was sent as a mediator to prevent the war, he offered a diplomatic solution, a legally binding agreement of peace between the Kauravas and the Pandavas, but he was not successful. तो क्लैरिटी होना डॉक्यूमेंट में बहुत जरूरी है. कॉर्पोरेट पर्सपेक्टिव इसके अराउंड यही है कि जो प्रोक्योरमेंट और सर्विस रिलेटेड कॉन्ट्रैक्ट्स हैं उससे फेयरनेस होनी चाहिए. कंपनी के जो इंटरनल डिस्प्यूट्स हैं, कोई एम्प्लॉय रिलेटेड इश्यूज हैं, वो भी सॉल्व होने चाहिए. और ऑफ कोर्स जो जिस इंडस्ट्री में मेजरली आज इसका यूज हो रहा है, यानी कि ई कॉमर्स और फाइनेंशियल रिलेटेड डिस्प्यूट जो छोटे मोटे होते हैं कि टाइम पे सर्विस नहीं मिला, ये नहीं हुआ वो हुआ, तो उसके लिए भी ये यूज हो रहा है. तो इसका फ्यूचर यही है कि हम अपने कॉन्ट्रैक्ट को स्मार्ट बनाएं, एक ऐसा एग्रीमेंट बनाएं कि जो कि डिजिटल फॉर्म में हो. एक टाइम पे हमें सर्विस मिली, ऑटोमेटिकली उसका पेमेंट हो जाए, क्योंकि मोस्टली ये कमर्शियल डिस्प्यूट्स है, पैसे का लेन देन से रिलेटेड है, हिस्सेदारी को लेके रिलेटेड है. तो हम अपने एग्रीमेंट्स को, हम अपने कॉन्ट्रैक्ट्स को एक इलेक्ट्रॉनिक फॉर्म में कन्वर्ट करें. सो दैट इज द आइडिया दैट आई वांट टू प्रेजेंट टू द स्टूडेंट्स हियर. एवरीबॉडी इज फ्रॉम द लीगल बैकग्राउंड. तो अगर किसी चीज को स्ट्रॉन्ग करना है, जैसे हम बोलते हैं कि ओडीआर होना चाहिए, तो ओडीआर के अराउंड का इंफ्रास्ट्रक्चर भी तो आप थोड़ा देखो कि वहाँ पे इंटरनेट अवेलेबिलिटी, डिजिटल लिटरेसी, लीगल लिटरेसी, ये सारी चीजें हैं कि नहीं. तो अगर किसी भी चीज में आप कोर्ट में प्रेजेंट करोगे, आप बोलते हो कि हमारा इतने सारे डॉक्यूमेंट्स हैं, हम पूरी फाइल्स लेके जाते हैं बड़ी बड़ी, लेकिन उस फाइल्स में क्रक्स की चीज सिर्फ 1 या 2 पन्नों में लिखी होती है, वो सब इधर उधर बाकी की बातें होती हैं. तो अगर वो क्लैरिटी अगर आप पहले से रखोगे तो अच्छा रहेगा, बेहतर कॉन्ट्रैक्ट्स बनेंगे और आपको प्रॉब्लम भी नहीं आएगी. तो ये प्रॉब्लम एक्चुअली ये जैसे आपने पता ही है आपको कि हिंदू माइथोलॉजी में अगर आप मानते हैं तो एक काल चक्र है. ठीक है, काल चक्र में सबसे पहला सत्ययुग था. कोई किसी से बात भी नहीं करता था, आत्मा का कनेक्शन होता था, वो सारी चीजें हो जाती. समुद्र मंथन हो गया उस टाइम पे. त्रेता युग में थोड़ा चीजें लोग फॉर्मल हुए, रिस्पेक्टफुल हुए, कुछ कॉन्फ्लिक्ट्स हुए, कुछ स्ट्रेटेजी बनाई लोगों ने, तो उस युग में रामायण हुई. फिर द्वापर युग आ गया जिसमें लोग थोड़े इंटेलेक्चुअल हुए, स्ट्रेटेजीज बनाई, रिटन और स्पोकन भाषा बोली, उन सब चीजों पे ध्यान दिया. तो इसमें लोगों ने डिसेप्शन किया, मैनिपुलेशन किया लोगों के साथ में. और एक इसमें धर्म, अगर धर्म पॉइंट ऑफ व्यू से देखें तो कुरुक्षेत्र की लड़ाई, भगवत गीता इस टाइम पे लिखी गई और महाभारत भी इसी टाइम पे लिखी गई. अभी चल रहा है कलयुग. कलयुग है एक मैनिपुलेटिव नेचर को दिखाता है लोगों के. जितने भी लोग हैं आज की डेट में मैनिपुलेट होते हैं. फेसबुक देखते हैं, वो आपको एक पर्टिकुलर डायरेक्शन में लेके जाने की कोशिश कर रहा है. आप कोई ई कॉमर्स वेबसाइट देखते हैं, वो आपको एक पर्टिकुलर डायरेक्शन में लेके जाने की कोशिश कर रहा है. ठीक है, तो आपको मैनिपुलेट कर रहा है. आपको झूठ बोलना और मिसअंडरस्टैंडिंग होना बहुत कॉमन हो गया. और बहुत सारे कोर्ट केसेस जो भी यहाँ पे एडवोकेट्स हैं, जो जस्टिस ऑनरेडी जस्टिस हैं, उनको पता है कि मोस्ट ऑफ द केसेस आर जस्ट ईगो इश्यूज. तो इस पॉइंट ऑफ व्यू से इसको देखना चाहिए. इसमें मैं इसको बस वाइंड अप करना चाहूँगा और इसमें लीगल टेक इंटीग्रेशन का बहुत बड़ा रोल है। कहीं पर भी जब हम ई या आई या ऑनलाइन की बात करते हैं तो वहाँ पे सब्जेक्ट मैटर एक्सपर्ट्स का होना बहुत जरूरी है। टेक्निकल फील्ड में ऑफ कोर्स बहुत ज़्यादा डेवलपमेंट हो गया है, बट लीगल पॉइंट ऑफ व्यू से किसी चीज़ को कोड में लिखना, किसी लीगल लैंग्वेज को कोड में कन्वर्ट करना इज अ ग्रेट जॉब। दैट फॉर दैट लीगल रिप्रेजेंटेटिव्स आर रिक्वायर्ड। तो मैं इसको वाइंड अप करता हूँ और आपको सिर्फ एक बात बोलना चाहूँगा। अगर आप सब लॉ बैकग्राउंड से हैं, आपने देखा होगा कि जो हमारे लोअर कोर्ट्स हैं उसके लोगों में लिखा है सत्यमेव जयते, ठीक है। हाई कोर्ट के लोगों में भी लिखा है सत्यमेव जयते, बट सुप्रीम कोर्ट के लोगों में सत्यमेव जयते नहीं लिखा है। उधर लिखा है यथा धर्मस्ततो जय, विक्ट्री उसकी होती है जो धर्म के साथ है। तो सिर्फ रिस्पॉन्सिबिलिटी क्लैरिटी की है, धर्म क्या कहता है उसके हिसाब से आगे बढ़ने। सो विद दिस नोट आई वुड लाइक टू एंड माय।
Thank you for sharing your time and knowledge.
Yes. Honorable Justice Rajesh Tandon with us here. Please give a huge round of applause, please. Sir, we extend our heartfelt gratitude for gracing this occasion with your presence.
For the last speaker for the first session, I would like to call Mr. Imtiaz Ali, a seasoned mediator and an advocate at Supreme Court, to share his expertise on ODR.
So the topic of today is online mediation and arbitration. So far as the mediation is concerned, I will confine myself to that because of the online mediation. Now, so far as the topics, the list of topics which have been prepared, the topic also experience during the different sessions of mediation that the session is concerned. I personally felt what are the obstacles during the course of mediation while we are conducting the session through online mode. So personally I feel there is no obstacle. So only two things are there. One, that the technical glitches. In case if the technical glitches are there, then we are handicapped in conducting the session properly to make the party convinced or to properly convey the message and the exchange of opinions or views between the parties. This will be one. Secondly, contrary to online mediation, if it's a physical mediation, the party is present physically, so some sentiments which represents the race of the body race, which works at that time, certainly makes a difference. While the online mediation is not able to do that. So this is personally what I felt during the course of mediation sessions. But it is good. Initially, we always conduct the mediation through online session, and online we are in a position to convince the parties 50%, 60%, and sometimes 70-80% also, so that they could turn up and come down to Supreme Court mediation center physically, sit, settle the dispute, and sign the settlement agreement. So unless and until the ODR is not there, we are just unable to convince them to bring them to the center to settle the dispute physically. So this is the pre-stage. So it's a good initiative. Through this platform, we can convince more and more parties to come down and to bring up our solution.
And I would like, because my Justice Tandon Sir is here, and he is my senior colleague at the time when I was practicing at the Allahabad High Court. So now I have shifted it, and he is waiting for his turn. So I would like to not take much time of you. But at last, I would conclude myself with the two lines, Urdu couplet, which is some film song also. I don't know, and that is. दूर रहकर न करो बात. When we initiate this process, everybody sits online distance. Somebody is in this city, somebody other city, somebody is at home, somebody in the mediation center. So we say, दूर रहकर न करो बात, करीब आ जाओ. दूर रहकर न करो बात, करीब आ जाओ. आज बस में नहीं जज्बात, करीब आ जाओ. हमें इन जज्बात को enhance करना होगा.
Bachelor's degree at Banaras Hindu University, an LLB from Campus Law Center, and an LLM from Nalsa. With specialization in intellectual property rights, copyrights, and civil law, Advocate Gaurav Kumar brings in-depth knowledge and experience to today's discussion. Please join me in welcoming Advocate Gaurav Kumar.
Our honorable guest, distinguished members, and most important part of this symposium, our respected listeners, because you are listening with essence. And before starting, I would like to start my lecture with simple point. Why do we need ODR, or in other language, why ODR is relevant in present time? Either we are from legal field or other, we all know a simple sentence, very popular sentence: justice delayed, justice denied. And its Hindi version, or we can say in Bollywood language, तारीख पे तारीख. I think you all know that. And fortunately, tagline of eVarta is तारीख पे तारीख no more, justice at your. So, and country like India, having a population more than 1.45 billion, and backlog of cases is more than, I think, 4 million. In such a situation, innovation of ODR or arrival of ODR is like breath of fresh air. In present time, we all know that mediation is part of our judicial system in solving our problems. But after the arrival of COVID-19, we started using technologies. COVID-19, the concept of ADR gradually transformed in ODR, online dispute resolution, where we use technology to settle the matter between the parties. The topic of online dispute resolution is not just an innovation, it is a necessity for a nation where pendency of cases gradually increasing day by day. In such a scenario, we need to approach ODR and the beauty of ODR lies in such a situation when a farmer seeking sending their commodity to the other part of our country. And in such a situation, if any dispute arises between them, each ODR is able to provide them a solution. And I think in such a situation where they are not able to travel, or they are not subject matter is not so much that is they would afford the cost of traveling and other formalities of court. In such a situation, ODR can help them smoothly, and it can also help to resolve their disputes. I would like to come on the topic as proposed by Sunanda ma'am initially. There are some points proposed by Sunanda ma'am initially. Our legal framework challenges in applying ODR and approach of Niti Aayog and our Supreme Court. I would like to mention important case of Supreme Court. Greed Corporation of Odisha Limited, that is totally relevant in case of ODR. Greed Corporation of Odisha Limited versus AES Corporation made a noteworthy observation that when an effective consultation can be achieved by resorting to electronic media and remote conferencing, it is not necessary that the two persons who are required to act in consultation with each other must necessarily be together at one place unless it's a requirement of law or a contract between the parties. जब तक की सिचुएशन नहीं है कि दोनों पार्टी का साथ में बैठना अपने डिस्प्यूट को रिजॉल्व करने के लिए, they can meet through the technology or advanced technology, that is the demand of ODR. But in a country like India is a developing nation. 2-3 problems are very prevalent in applying ODR. The first is digital infrastructure. In our country, still we are facing problem of connectivity. And I am aware after the COVID, hybrid mode is all over India, but prevalently in Delhi, hybrid model is used. But sometimes we feel the problem of connectivity within the code. So, first problem is digital infrastructure. Second problem is digital illiteracy. In current scenario, not all people know how to use the technology and other things. And the third thing, lack of trust in the process of ODR. And the fourth problem we will face to applying ODR is privacy concern. If two parties share their valuable documents through ODR, who will guard them? So, in my opinion, these 3-4 problems that will face when we try to apply ODR, these 3-4 problems will face. So it will be initiative of government to spread, and I think the government is doing. Taking initiative in this direction to enhance infrastructure, digital infrastructure, digital literacy, and other things to promote ODR in this direction. Thank you so much for Team eVarta for taking this initiative and applying their time, energy, and resources in such an innovative and progressive idea. Thank you.
Thank you so much, sir. Ladies and gentlemen, we are honored to have our esteemed chief guest, Honorable Justice Rajesh Tandon. Justice Tandon is a towering figure in the field of law, with an illustrious career spanning decades. He was enrolled in the bar in 1968 and was designated as a senior advocate by the Honorable Allahabad High Court in the year 2000. His invaluable contribution as a judge of the Uttarakhand High Court from 2003 to 2008 have left a lasting impact on the judiciary. It is an absolute privilege to have such a distinguished legal luminary amongst us today. We eagerly look forward to his invaluable insights and wisdom. Sir, we extend our heartfelt gratitude for gracing this occasion with your presence, and I would like to call you to the stage, sir.
Thank you very much. On the dais, my brothers advocates, Shindaji, who has just completed her AOR degree from the Supreme Court, my advocate brothers, I'm sorry I was late, as I was in a mock interview in the Ambition Academy, and thereafter, when I have seen that your program has started, I have just rushed from there. Sorry for that. The topic of ODR system, I may tell you that ODR is nothing. It is a shape of ADR, because ODR means dispute resolution online, but it is an alternative dispute resolution. Therefore, wherever I see only word ODR, I used to point out that it is ADR in the shape of ODR, because ADR, alternative dispute resolution, is the arbitration, settlement, mediation, and arbitration. We do it online also, that you may say it online, and we may do it physically also, and therefore the organizers of this program, I will say, change the name as alternative dispute resolution in the form of online dispute resolution, and that will be serve your purpose. The Arbitration Act, all of you are aware that it started from 1940, where the disputes were resolving it at that time. That took at least 20 to 25 years to settle, because once the award is passed, you have to move for making the rule of the court, and thereafter the rule of the court means that complete CPC applies, and sometimes the rule of the court was not decided in the lifetime of that person, and therefore, thanks to our government and also the United Nations, where it was passed that the alternative dispute resolution be such so as to permit the applicant to take the fruits of the degree, and that in 1996 it came into force, And that since that time, 1996, various amendments were made from time to time, and now at present it is known as two types of arbitration, that is institutional arbitration or ad hoc arbitration. Institutional arbitration is being done by the institutions like High Court, ICI, or Indian International Center, which was recently formed by the Supreme Court, headed by Justice Hemant Gupta, of the retired judge of the Supreme Court, and the matters are being referred under section 11 bracket 6 of the Arbitration and Conciliation Act. Coming to the ad hoc arbitration, the ad hoc arbitration is simply governed by section 7 and 8 of the Arbitration Act. Two parties may combine themselves for referring the matter to the arbitrator, and if the parties may not agree for a particular arbitrator, then the matter goes under section 11 bracket 6 of the Arbitration and Conciliation Act, and the institutional provision comes into play by the High Court or the Supreme Court for appointment of the arbitrator. Recently, various judgments have come up of the Supreme Court where it has been laid down that if the other party is not giving consent for a particular arbitrator, then the provisions of sections 7 and 8 of the Arbitration Act does not apply, and one has to go for institution under section 11 of the Arbitration and Conciliation Act. These are the provisions for referring the dispute to the arbitrator, but sometimes the arbitrator has also to give a declaration that he is not known to the parties of whom the matter has been referred. That declaration is granted under section 12 of the Arbitration and Conciliation Act, and thereafter there is another provision, section 13 of the Arbitration and Conciliation Act. Recently, there was a matter in the Supreme Court which I have argued. There was a provision in the agreement that there will be 3 arbitrators. One has to be appointed by the one party, the other is another, and both the parties shall appoint a presiding arbitrator. The matter has come up when the court himself has appointed a sole arbitrator instead of 3 arbitrators. No objection was taken at that time, and the matter proceeded. Arbitration award was made, by sole arbitrator. Then the matter went under section 34 of the Arbitration Act. In section 34, the objection was taken that according to the agreement, only 3 arbitrators can be, and therefore whole arbitration award is null and void. It does not stand. Section 34 application was allowed, and the whole award was set aside. The matter went in appeal. The appellate court also set aside the award. Then the second appeal also under section 37 of the Arbitration and Conciliation Act, that was also confirmed that on the eye of law, the award does not exist at all. The matter came to the Supreme Court, and there was a flaw in that. When the matter was referred to the sole arbitrator, both the parties have proceeded and have made no objection. Section 13 requires that objection has to be taken before filing the written statement, before taking defense. That was not taken up, and parties have proceeded. Just 2 weeks back, Justice Oka I have argued the matter that becomes a final, and section 13(2) cannot be relaxed, and that objection has to be taken at the relevant time when the defense was filed and when he has participated in the arbitration proceedings. Later on, he cannot say that the arbitration is bad or does not exist in the eye of law. Therefore, all the advocates who are present here, read section 13, 16 and section 12. These 3 sections are very important. 12 relates to declaration, 13 relates to the objections, and 16 is the power of the arbitrator to decide about that objection. All the 3 are connected together, and one has to be cautious while arguing the arbitration matters. Although it is a small act of 30, section 30 up to section 30 that relates to settlement, and 3-4 section more, 34, 37. But all the sections have some meaning. They also define certain foundation, how to deal with it. Therefore, the arbitration work is not so simple that you can proceed without understanding or without reading carefully. Sometimes it creates confusion. Large number of cases are there where powers of section 34 has been given. Some of the courts say that no interference can be made, but where the award itself is an honest award, that it does not deal with the elements of the agreement, it becomes a non-est award. It can be dealt with, and section 34 comes into play. Similarly, 37 also. But all these points have to be made out at the proper stages. There was a judgment of this Honorable Court, the Supreme Court, that is Connaught Railway. It's a very old judgment. When the Arbitration Act has come up in 1996, this judgment has come up where Justice G.P. Mathur, at that time he was in the Supreme Court, has laid down the law that all these powers are within the jurisdiction of the arbitrator. He can decide the complex of section 1230 under section 16 of the Arbitration Act, and therefore the matter may not prolong further. Arbitrator is the best person to decide under section 16 of the Arbitration Act. This Arbitration Act is not known as a new act. If you look to section 89 of the Code of Civil Procedure, you will find the powers have been given under the Code of Civil Procedure also for arbitration, settlement, mediation, but these powers are not being exercised by the lower judiciary. Why it is not being? Because if you will refer the matter to the arbitrator, then what will be the result? I have not seen any district judge referring the matter, when in point of fact, section 89 deals with the referring of the matter, and it also deals, section 89 subclass 2, that the matter shall be decided in accordance with the Arbitration and Conciliation Act. Therefore, but request this society to emphasize the applicability of section 89 also. The half number of the cases will be decided by the arbitration when the matter is referred under section 89 of the Code of Civil Procedure. All these are very prime issues, and therefore this society must function towards the implementation of and enforcement of section 89 of the Code of Civil Procedure. Both the provisions have been given that the matter can be referred and then it will be decided under the Arbitration and Conciliation Act, and other that it will be decided under the Legal Services Authorities Act by the Lok Adalat also. All these provisions are there, but it is seldom used by the lower judiciary. Nowadays, Lok Adalat has become very prominent under the Legal Services Authorities Act, and under the Lok Adalat, many matters are being decided for which the court cannot give time of so much. Even for settlement, the person has to wait for getting the matter decided. The matters under the Motor Vehicles Act, matters under section 125 CRPC, matters under 138 of the Negotiable Instruments Act all are being cognizable by the Lok Adalat. And Lok Adalat is the best course to decide all these matters, and therefore this society must provoke for the settlement of the matters by Lok Adalat, by mediation. Mediation is nothing. Nothing can be done in mediation. Even if the matter is referred to the mediation, the mediator has to keep the matter as confidential. There is no use then, and therefore Section 89 and Section 7(8) be invoked for settlement of the disputes in all the matters. I'm sorry I have taken much time. Thank you very much. Jai Lok Adalat, Jai Section 89 and Jai Section 7(8) of the Arbitration Act.
I now request Professor Anurag, Deep and Mr. Avinash from eVarta to please present memento and shawl to Justice Tandon as a token of gratitude.
Good evening, everyone. Honorable judges, senior advocates, respected professors, distinguished guests, legal professionals, and esteemed colleagues. I stand before you today to discuss one of the transformative forces in India's justice system. As we know, human conflicts are inexorable because society is multifarious web of social relations. The fundamental idea behind ODR is simple. Justice should not be confined to physical courtrooms. After listening all the dignitaries, now I think so all of you get friendly with the concept of ODR. So now I move further to highlight the other important aspects of ODR. In recent several years, several initiatives have been undertaken to promote and implement ODR in India. The government has recognized the importance of ODR and has taken steps to integrate into the legal framework. The Niti Aayog, for instance, has been instrumental in advocating for ODR adoption and has released reports outlining its potential.
Excuse me, students. Somebody is putting the efforts in that. Please recognize the efforts of the speaker. Maintain the decorum.
Thank you so much. I would like to highlight the chronology of ODR. First of all, in 2006, National Internet Exchange of India adopted the domain name that is IN. Later on in 2017, when the Modi government came, the Ministry of Law and Justice urged government agencies to resolve disputes through online arbitration. In 2020, the government launched the Vishwas scheme to resolve tax disputes through ODR. And in 2021, the most awaited Niti Aayog Expert Committee, chaired by Honorable Justice A.K. Sikri, recommended widespread implementation of ODR in India, from where this project came up. India's digital infrastructure, coupled with its increasing caseloads of dispute, makes ODR a necessary and viable alternative to the conventional litigation. there are so many of other things which have been discussed by the dignitaries. So now I came forward and discussed with all of you guys that what our eVarta vision is. The vision of eVarta is our startup will offer you an online platform which gives you resolution online like medical claims, disputes. Britain already done it, that first mediation have been conducted through ODR. E-commerce disputes, cross-border disputes, and banking disputes. And later on, we will move further to B2C disputes, like business to consumer disputes. And how our eVarta identify problem in phase-wise manner. I would like to discuss the young audience before you. First of all, we follow the procedures like diagnosis and information. The second one is intake, and the third one is dialogue between the parties, and the fourth one is trialogue, like between the parties, between the expert team, and between the whoever approaching us. And the fifth one is external online review. Sixth, online adjudication if required, that is fee-based. And the last one, 7, that is aftercare. Our program takes a person through a series of questions on a justice journey. It's a journey in which the system interacts with the answers provided, or our experts will interact. Advice, information, options, and tools such as we record as a maintenance calculator are supplied as required. It is thus inherently dynamic and oriented towards settlement. Whether decisions are to be made, the intention is to highlight to the parties the best alternative to negotiated agreement which sets the parameter for a settlement. Now I am going to highlight what's our revenue generation model. So first of all, we are highlighting that is licensing fee service, in which individuals, business organizations will pay licensing fee to use the eVarta ODR platform for resolving disputes. Then after, online deposits of fees and costs. The third one is smart contracts, which our earlier speakers also talked about. The fourth one is fee for services, in which individuals and businesses pay for legal advice and dispute resolution services. And in fifth, employment fees, like whoever ADR practitioners wanted to use our eVarta platform, they'll have to pay some charges. Today I would like to take this opportunity how the germination of ODR seed take place. Me and Viswajit Sharma Bhaiya, who is sitting here, are the student of cyber law, a student in Indian Law Institute. During the project submission, his project was on ODR, and further we discussed each other approx 6 months. We have also taken meetings in various hotels and financiers. Later on, Advocate Yogendra Sir, Honorable Justice Sir S. Mukherjee Sir, since 2024 we are discussing, now we reach here with all the legal experts like Yaspal Sir, Honorable AOR Silpa Bagare Ma'am, Dr. Anil Sen Sir, Ali Sir, Yaspal Sharma Sir, Santosh Sir, and I also thank Mr. Avinash to collaborate all of us. I request to all of you that please enlighten with your guidance, approach and contribution to germinate our seed, that is eVarta, as a tree. And in my concluding, I would like to say some points. The integration of ODR in India represents not just a digital upgrade, but a paradigm shift how justice is delivered. With a strong legislative framework, technological investment and collaborative efforts among stakeholders, ODR can bridge the gap between legal accessibility and judicial efficiency. ODR is not just a technological innovation, it's a social and legal revolution. It represents a fundamental shift in how we approach conflict resolution, offering an efficient, accessible and equitable alternative to traditional litigation. As India continues its journey towards becoming a digital superpower, ODR will play a crucial role in ensuring that justice is not just a right, but it's reality for all. Thank you all.
In fact, I was traveling and I've come directly to the venue and I'm not really well prepared, but I'll speak a few words on the online dispute resolution.
Yes.
Through my experience, because I'm also an arbitrator, I take up arbitration, I'm on the panel of ICA, I'm on the panel of DIAC, and I appear as a counsel also in some arbitration matters. When I joined the profession in 1992, the internet had just come in. And the first online dispute resolution mechanism was introduced in the domain name dispute resolution. You have the WIPO and some of those, the international bodies which would conduct online dispute resolution over domain name disputes. Of course, then came the arbitration in the physical world, and finally we had the pandemic in 2020. Necessity is the mother of invention. I would just modify it. Necessity is the mother of law also. So therefore, now after the pandemic, we have adapted ourselves to the online resolution, online hearings. Pandemic has gone by, long back. We are back in the earlier world, but the online dispute resolution mechanism is here to stay. Even now in the courts of law, in arbitrations, many hearings take place through the online mechanism. My experience as an arbitrator and as a counsel has been that at least 90% of the work can be done through online methodology. Maybe, for example, I was an arbitrator in a very high-stake dispute between the contractor and the government authorities, and the venue of arbitration was Bangalore. And I visited Bangalore 6, 7, 8 times, but only for the purposes of cross-examination to be done in my presence and for final arguments. Otherwise, all the other preliminary hearings, important hearings, in Section 16, all of that took place through the online mechanism. Now, some of the benefits of the online dispute resolution, which I can see, it's very cost effective, highly efficient. Now, what is the future? I would want to just speak about the future of online dispute resolution. How it changes the landscape of ADR. I foresee that a lot of small disputes, where consumers are involved, for example. Or the other day I was attending a very interesting session. I was a panelist on mediation. And I think one of the co-panelists, Mr. J.P. Singh, senior advocate, my colleague and a dear friend, he spoke of how so many disputes can be mediated. And he gave examples like, in the RWA, disputes between neighbors. So similarly, I foresee so many small disputes. Otherwise, for a consumer, for a small consumer to invoke the arbitration it's an impossible, it's impractical, not feasible commercially at all. And it's a daunting task for him. But like online dispute resolution of domain name disputes, if the consumer law also, if we can have ADR which is purely online in nature, which means no cross-examination, nothing. And so therefore these are the kinds of small disputes which can be mounted on the ADR platform, on the online platform. So I see a revolution happening in the times to come in the online dispute resolution. And so that's about it. I wish I could have come earlier, and I wish I would have been prepared on some other topic also. But this is all I want to say. and congratulations to all of you. Justice Mukherjee just told me that this function this session was a big success, and we had a very good crowd, a very good gathering, and people have just left a while ago. And my congratulations to the organizers, and please organize more of these sessions so that we can be brainstorming between experts, between stakeholders, etc. So congratulations once again, and I'm grateful for inviting me on the platform out there. Thank you very much. Thank you.
Thank you so much, sir. We truly appreciate your participation in the events. Thank you. For the last speaker, we have Anushka Das Gupta, a final year law student at the Faculty of Law, University of Delhi. She has been a research intern at eVarta. She will discuss online mediation as a tool for justice accountability.
My paper focuses on media as a tool which can increase access to justice. No matter how innovative or how futuristic some legal mechanism is, we are ultimately interested in whether or not it can increase our access to justice, because that is our ultimate goal. So in my paper, I focused on limited scope, which is first, what are the types of litigants who are likely to be benefited from ODR? Second, what are the types of disputes which can be easily solved through ODR? And third, how ODR systems can be designed in such a way that we can unlock its full potential. My resources were mainly relevant legal literature from across the world, because in many countries ODR systems are already up and running. And in the Indian context, I refer to the NITI Aayog's report because it looks into the feasibility of ODR systems for India in particular. Once a researcher ordered a book, a very expensive and valuable book, from a different country. But to her dismay, she found that 30 of the most important, the most crucial pages were missing from the book. Now, in a usual situation, many of us might choose to suffer injustice. We might do that. And financial constraints is not everything. Even if we set that aside, there are bigger constraints, like the long-drawn complexity of legal proceedings. Just try and imagine the number of offices we might have to go to, the officers we might have to deal with. One finds it much better to give up on those things. But with ODR, this big physical limitation can be overcome. That proverbial pillar to post, running from pillar to post, that can be a thing of the past. So it's not only very good for senior citizens, people with disabilities, for whom very unfortunately courts are still not a very friendly premise. For them, and also for everybody else, for whom pursuing a case would not mean that they have to give up their daily normal routines and all their earnings just to go after justice. So ODR can have great potential there. There are other more subtle barriers that ODR can help us overcome. We were discussing about how AI might play a very important role here. There's one big advantage of technology that most people of our generation actually make great use of. It actually lowers biases, the inbuilt human biases. For a country like ours, where surnames have such a massive story behind them, for a country like ours where we judge people on their appearance, we might treat them differently on basis of how they look, how they speak. ODR, because it's based purely on text and the need for physical appearance is not essential, this can actually be a great advantage. We are leveling the playing field for many litigants here. They need not feel judged, they need not feel exposed to somebody's opinion. The type of dispute that ODR can deal with, as we have already been discussing, these are those low-value disputes. At the moment, these are the types of dispute that ODR is predominantly dealing with, but these are also high in volume, so it can free up courts to take up more complex issues. My other focus is that ODR focuses on those disputes which have arisen in the cyberspace to begin with. Those of us who are content creators here, we often get into a lot of trouble with copyright claims.
What about those issues? Where can we deal with them? Or think of a Nike product you might have ordered and you find it expired. What will happen to those? So these are small things, but they actually take up a major chunk of our code loads that we can deal with via ODR. And it's more than just conducting ADR online. So ODR is definitely a natural successor of the ADR movement, but it's not just ADR in an online mode. Because ODR can also come with, say, in real-time translations, cutting across linguistic barriers. It can come with assisted negotiation. Technology will enable the negotiation. It can come with bidding processes. There are two parties who are trying to strike a deal, and technology will give them the most suitable deal. So ODR goes way beyond than just e-courts, for example. Now, the biggest challenge is all that is alright, but what is our level of preparedness as far as ODR is concerned? In a country like ours, the access to justice will first have to be preceded by access to technology to begin with. And we know this is a major priority of the government because we have so many initiatives, broadband mission, digital Sakshata Abhiyan. So they are all geared so that first we can at least improve technological access to begin with. Then we can think of ODR. The second issue that we can talk about is trust. Every second call is a scam. Every second message is a suspected junk. How can we trust online systems in such an atmosphere? I think institutions have taken a step here, which is if courts, like for example, we have e-courts, e-lok adalats, which dealt with disputes even over WhatsApp calls and messages. To think that WhatsApp calls and messages are now being used to solve disputes easily. So this can actually bolster confidence among people to resort to online dispute more. And we can have a standard, uniform online dispute resolution mechanism across businesses. In European Union, it's mandatory for businesses to have and to inform the customer that they have a recourse to online dispute resolution as well. So this is as far as our preparedness is concerned. We already have some level of statutory preparedness. The pandemic, as unfortunate as it was, it at least laid down the groundwork on which we can build future ODR systems. And as Nam was pointing out, that we are a country of 300 million Facebook users. For us, an online dispute resolution system should not be a distant dream. And hopefully in future, a buyer does not have to worry about 30 missing pages from their book anymore. Thank you.
Thank you so much, Anushka, for sharing the insights with us. I now request core team of Paryaya, the India Society of LC1, please present a memento to Senior Advocate Vivek.
Thank you.
Professor Upendranath Sir, to please present a memento to Yogi Mark.
Yes, sir, सामने. Yes, सामने. Yes, सामने. Thank you.
I now request Professor Apeksha Kumar to please present memento to Advocate Gaurav Kumar Sir.
Yes, right. Thank you.
Thank you, ma'am. Thank you.
To conclude today's session, I would like to invite Professor Anurag, Professor at Faculty of Law, Delhi University, to deliver the vote of thanks. He has previously served as professor at the Indian Law Institute, New Delhi, and specializes in criminal and constitutional law.
Whenever this thanks note starts, I always remember two lines. Look where in Viteria, so when I was that side, but I can say that because this event can be considered as an exception, because we are dealing with an issue which is very close to heart of every Indian. The areas and delays and delayed justice, it has become a norm. And if anything happens quick, we are surprised. So how did it happen so early? Delay not only in trial courts, but I have made a study and I have found that in the Supreme Court cases are pending, in the Supreme Court itself, the cases are pending for 12 years, 13 years, 14 years, even 20 years. So, therefore, this EDR is an answer, and ODR is another more convenient forum for many of us, provided we change a little bit of mindset also, like technology mein kaise hoga. This I have heard from many people. And then sometimes इसमें justice नहीं होता है. And then I remember a sentence that many times it is not the justice that we think is important. Many times moving on becomes more important. So there is a dispute, and the justice says that I deserve 20,000 rupees, but if I am being given 15,000 rupees, I must move on. So, I have seen this in Lok Adalat. I don't have time to discuss with you all, but I feel myself very privileged to be part of this wonderful endeavor. I will say the pious endeavor which Mr. Avinash, eVarta, and his team has taken. They contacted me. And I told that I am not the right person for this, but they insisted that we should be a part of this. And then Delhi University gracefully and willingly attached itself in the time when we are so much power driven. But I must appreciate the team, Faculty of Law, and Sunanda Madam, who immediately accepted the proposal and idea of a very, very little known startup. So that came as a boost to everyone. Now, to begin with, I'm thankful to all the panelists, because those in the audience, especially the young persons, the young stars, they have come to listen to you, and they have learned a lot, I am sure. So thankful to all the learned panel members of session 1, session 2. I am deliberately not taking the name of anyone. I am thankful to ISSL, media persons, the cameramen, technical staff, cleaning staff, canteen staff, the base of this work, where the student hosts, and I wish to name them, because if they तुम नहीं होते तो आज ये समान नहीं बनता है. मतलब नहीं कहूँगा, जोर से ताली सुकन्या, जूही, देवांशु, उद्धव, मेधा, कासिम और प्रज्वल, ये सभी लोग. विशेष रूप से मैं धन्यवाद दूंगा फैकल्टी के दो लर्नेड फैकल्टी मेंबर्स की जो है एक्सपीरियंस की बात. मैं एक बार फिर से सबको धन्यवाद देता हूँ, और विशेष रूप से कहूँगा कि अविनाश के लिए मैं कहूँगा कि तुम दरिया हो जिसे अपना हुनर मालूम है. तुम वो दरिया हो जिसे अपना हुनर मालूम है, तुम जिधर बढ़ जाओगे रास्ता बन जाएगा। Thank you.
We are immensely grateful to all of you for valuable presence today. eVarta and Paryaya Area Society of Influence hope that you had an engaging and enlightening experience today. With the wealth of experience and the expertise and the insights that our esteemed speakers have shared, we are sure that we all are leaving here with lots of deeper understanding and newer perspectives. Let's make the most of this opportunity to learn, reflect, and engage in meaningful discussions. Finally, we like to invite you all for high tea just outside the hall. Thank you once again for your presence. Thank you, everyone.
यस सर सामने एक मिनट वेट। यस इधर देखो सर, इधर देखो, मोबाइल पीछे कर लो। यस सामने देखना।